Good morning and welcome to the DC Court of Appeals. Before we start this morning's argument, we ask that you have your cell phones muted so as not to disturb this morning's arguments. Thank you. We'll be starting shortly.
Oh, yeah, it bothers me, just like a crooked picture hanging on the wall.
All rise. All persons having business before the Honorable Chief Judge and Associate Judges now presiding on the District Court of Appeals, draw near and give your attention. God save this United States and its honorable court. This honorable court is now in session. Please be seated. Come forward.
Good morning and welcome to the District of Columbia Court of Appeals. We have three matters set this morning. I'm joined this morning by Associate Judge Easterly on my right and Associate Judge Schenker on my left. I'm Judge Blackburn-Rigsby. Counsel, are you ready to proceed?
Yes, Your Honor.
Okay, in the first case of ZURI Berry versus American University et al.
Good morning. May it please the court. My name is David Branch and I represent ZURI Berry, the appellant in this case. This is an appeal from the dismissal by the DC Superior Court of two complaints, one for
Mr. Berry,
defamation.
I apologize for interrupting. Did you want to reserve some of your time?
My
for
apologies.
rebuttal?
5 minutes, Your Honor.
Thank you.
Yes. This is an appeal from the dismissal of two complaints filed in the DC Superior Court. One complaint alleging defamation, tortious interference, false light, invasion of privacy. The second complaint was a complaint essentially for discrimination. The complaints were dismissed under the DC anti-SLAPP statute. The court's decisions below should be reversed for a number of reasons. First, the DC anti-SLAPP statute does not apply in these cases because these cases involve private personnel matters and not an issue of public interest.
Can I stop you there just to ask you to explain further? You know, we have cases that have construed whether something is a private interest or public interest fairly broadly in the context of an anti-SLAPP case. And here, WAMU is a radio station. This issue was broadly publicized, and there is an article that was written as well about issues that could arguably be construed as issues of public interest. Can you talk a little more about why we should conclude that there was not a public interest?
Your Honor, the court just in the last term issued the decision of Close It Title Services v. Nadell. And that court, in that particular case, delineated between matters that involve personal interests. I believe in the Close It Title Services case, it involved an attorney who made defamatory statements. There was no one to benefit from the statements being made in this case, except the people who made the defamatory statements.
Close It seems far away from this case, just factually, right? You have to drill down into the facts, and then Close It, there's an issue about what the lawyer spoke to the press about was his client's particular experience with fraud, right? With hacking at a title company where his client sent money to someone that they shouldn't have. And it was very much about like, my clients want their money back, right?
Yes.
Whereas in this case, you have an article that's saying, hey, here's a news organization that has a problem with its workplace culture and management isn't doing anything about it. So it's not just about your client, it's about sort of a broader problem within a news organization that is reporting on other businesses and their workplace cultures. That seems like it's in the public interest. And not only that, you have Judge Sadler saying, look, this is a donor-funded news organization. So it's almost like, you know, the public owns shares in this news organization, and they might want to know where their dollars are going, you know, from all the fundraising that WAMU does. You know, they might be interested in this.
Your Honor, first, if you read the article closely, it seems to be just an airing of personal grievances that these particular employees anonymously cited by the article that these particular employees had about a particular manager. And Your Honor, I'm not sure how far the court is willing to go with this. So are we to assume that any employee at American University or WAMU who files a complaint against the manager, that instantly becomes a matter of public interest?
Sorry, there's an underlying issue here that is perhaps tied more broadly to public interest around Me Too, since these were sexual harassment, bullying, workplace toxic environment towards women employees. At least those are the allegations. That seems to be a story that's more broad than just this particular workplace, particularly when you put it in the context of a media organization such as WAMU.
Your Honor, I would respond by just saying the article basically says that Mr. Berry micromanaged and I think the word was mistrust that was used, women of color, did not support opportunities for the growth of the women of color. These are personal attacks
But
on
the
Mr. Berry.
article, as I said, the article goes beyond, I mean, certainly there's certain allegations about how people felt, right? And it seems to be couched as their feelings about him. But it goes beyond that, right? And I'm quoting, sources said that at both meetings, staffers said that morale at the station was declining. They had complained to their supervisors in an effort to prevent women of color from leaving, right? So the article is focused not just on your client, it's talking about what the broader workplace culture is and what management's response is or is not to issues about retention of women and women of color in particular.
Your Honor, yes, I will concede that's in the article, but the article also includes a photograph.
But I guess, doesn't our case law say you have to look at the broader context for what the statements are in assessing whether or not they are statements of public interest? I'm not getting quite the statutory phrase, it's a mouthful, but whether or not it falls under the Anti-SLAPP Act.
Your Honor, I think that this article, yes, it's true that you look at the broader parts of whatever the defamatory statement is, but here, Mr. Berry is specifically targeted. His photograph was placed with this article.
Did you allege that the photograph, the publication of the photograph was itself defamatory? I didn't see that in the complaint or in any of the
I think we
materials.
stated obviously that his photograph, that the article included his photograph.
Sure, it's
And-
acknowledged that the photograph's in there, but is the inclusion of the photograph itself some sort of defamatory act, right? I mean, when you allege defamation, you actually have to pick out particular statements and say, here's a statement that is, insulting, undermines my reputation, right? And it is actionable, right? It's not just opinion. It's not materially true, right? It was published. You have to go through all of those steps. And I didn't see any analysis of the actual photograph as a statement.
We did not specifically say the photograph was a statement. We stated that there was a photograph, plus it included the statements. The title was WAMU licensee investigates editor blamed for departure of women of color, with a photograph of Mr. Berry. It further states.
Well, the first photograph actually is a photograph of WAMU.
Yes, but it includes a photograph, of course, of Mr.
Right.
Berry. And then it states that Katz read a letter from an employee that Berry mistrust and micromanaged women of color and did not support opportunities for their growth. It included statements that women of color left their positions, anonymous sources that they left their positions because of Mr. Berry. And Your Honor, I would add on the comment on opinion, even if statements are opinion, if the opinion can reasonably be interpreted to declare or imply untrue facts, the statements can be defamatory.
So on the subject of opinion, I didn't see actually in your brief any argument contesting the trial court's ruling that these statements were non-actionable opinion. I didn't see that in your brief.
Your Honor, well, if it's not there, but I can't really address the fact that.
Can I ask an additional question on that same front? Your colleagues on the other side focus on the fact that you aren't also challenging the Anti-SLAPP Act's applicability to Berry 2. And I don't see that in your brief either. Are they wrong? And if so, can you point to a specific argument about Berry 2?
whether we are applying,
Whether you're challenging the applicability of the Anti-SLAPP Act.
yes, Your Honor. So the Berry 2, the court found that Berry 1 basically, the finding in Berry 1 was binding on Berry 2. So
Well, the trial court
Claim
actually did
preclusion.
3 things. The trial court said first, Berry 2 is precluded by is barred by race judicata by Berry 1. Then separately and independently, it said Berry 2 is barred by the Anti-SLAPP Act, just like Berry 1 was. And third, it made a 12B6 ruling and said we failed to state a claim vis-a-vis defamation, tortious interference, false light, DCRA, right? So it did all of those things. And in your brief, I only see an argument attacking the 12B6 ruling.
Your Honor, I also believe we made an argument that the court's finding on res judicata or claim preclusion was the court erred in reaching that finding.
Well,
Your
maybe
Honor.
when you sit down before you get back up on a rebuttal, you can show us where that
But-
is.
And the next issue, Your Honor, is the major issue in this case. The court just issued a decision in Banks v. Hoffman where the court found that denying limited discovery, and that limited discovery should be permitted if someone files a
Right, and
motion to
I
dismiss
didn't,
under the anti-SLAPP
I
statute.
didn't see an argument in your brief, in your initial brief, that you were seeking discovery and their request for discovery should have precluded the court from ruling on your anti-SLAPP motion. In your initial brief, it seems to be couched as an argument that because American and the other defendants attached exhibits to their anti-SLAPP motion, it converted it into a motion for summary judgment, which should have, then should have been litigated in that posture. In your reply, you make it more targeted, saying, hey, we should have been given discovery before the court ruled on the anti-SLAPP motion, but we typically don't accept new arguments in reply briefs.
Your Honor, that's always been the argument. That's why we made the motion for targeted discovery. And I would note.
I understand it's the argument that you made in the trial court, but if you look at and maybe again, when you sit down, you can show me where you say and cite any cases to say that you were entitled to discovery before the court ruled on your anti-SLAPP motion.
And in the Banks v. Hoffman case, the court actually permitted limited discovery. This court still reversed the trial court, even though that court permitted limited discovery. We weren't permitted any discovery, even targeted discovery that we requested in this case.
Mr. Banks, before you sit down, I wanted to quickly take you back to my original question about public interest. You cite almost exclusively California cases and authority. Is there any case law from our jurisdiction? I know you mentioned the Close It case. I'm not sure that applies here because the issues here, I think, are much more broad in terms of their potential public impact. Is there any other case you would cite us to?
Your Honor, there is no other case that I can cite to on this point.
You reserved your 5 minutes for rebuttal. I know we've asked a lot of questions.
Okay.
We'll give you your rebuttal time when you sit down.
Chief, sorry, do you have anything that you want to say about the damages award?
Yes, in terms of
I mean,
damage-
the attorney's fees award?
the attorney's fees award, Your Honor. Of course, if the court reverses on the, anti-SLAPP statute, which we believe the court should do, that completely nullifies the attorney's fees. But secondly, we did argue that the attorney's fees were excessive. I think it was $130,000 for the first case, and then over $200,000 for the second case, which is basically.
It's a large fee award, but I'm trying to understand what's the basis for your excessive argument other than looking at the total figure?
Your Honor, before the trial court, we actually went through, of course, we had page limits in this court, in the briefing in this court, which we asked the court to exceed, which was denied. But we had, we detail in our arguments before the trial court.
Right, but they're not,
The excessive
in your
billing.
brief to this court, you don't cross-reference those arguments. There's no, there's no argument, it seems, supporting the excessiveness. There's no analysis supporting the excessiveness argument other than to say it was excessive.
Yeah. This was 4 appeals combined, Your Honor. We requested from the court to allow us to exceed the page limit. That request was denied. So we put all the information that we could, all the argument that we could in the brief. But we raised this issue before the trial court.
All right, thank you, Mr. Branch. We'll reserve your rebuttal time.
Good morning.
Morning.
Morning, Your Honor. May it please the court and counsel. My name is Charles Tobin. I'm with the law firm of Ballard Spahr. With me at counsel table is Alia Smith. We represent American University, its publication Current, and the 6 women who have been named as defendants in Berry 1, excuse me, and then American University is the sole defendant.
Can you tell us why you think this case falls under SLAPP because it's within the public interest?
Certainly, Your Honor. And, I would point first of all to Mr. Berry's own allegations, both in the complaint and in the way he has pleaded this case throughout. In Berry 2, paragraph 7, he identifies WAMU as a national public radio affiliate that had suffered years of bad publicity. So he pleads a pre-existing controversy in the public realm involving WAMU. He then pleads in Berry paragraph 10, after the George Floyd murder and the beginning of the BLM protests, he became involved at WAMU in its racial reckoning that many employers were going through, hopefully all employers were going through, in serving on the DEI committee and putting out emails to staff and things of that nature.
Which of our cases would you rely on that distinguish those, as opposing counsel argues, individual issues with respect to Mr. Berry? Which aspects of which cases, I guess, most strongly align with the argument that this factual background puts it in the public realm?
I would ask the court to rest on Judge Easterly's excellent work in the Saudi Arabian Public Affairs Committee, the SAPRAC case, in which that case involved allegations in the complaint that there were rival organizations about public policy relating to Israel, and at the same time, allegations by the plaintiff that he was personally being pursued and harassed by the defendant's chief executive. And Judge Easterly and this court in that opinion said that the intermixing of public and private, which was the allegation in that case, is not disqualifying, that to give full breadth and full freedom of speech under the Anti-SLAPP Act, there must be some play in the joints for the intermixing of public and private interests. We believe that Mr. Berry has actually pleaded a complete public interest in the conduct of supervisors and the treatment of women, particularly women of color.
So counsel,
WAM.
public interest is defined in the statute. And to me, maybe you disagree, and please tell me why. It seems to be defined not as an illustrative list, but as an exclusive list. Issues related to health or safety, environmental, economic, or community well-being, the district government, a public figure, or a good product or service in the marketplace. Can you tell me which of those you think this falls under?
Looking at the statutory language, I would say most closely aligns with the provision of a good or service to the public. He pleads, and this court's questions acknowledge that WAMU is a leading news media organization in the DMV. Additionally, the entire notion, the entire discussion we're having about racial reckoning in the United States goes to the community health, goes to the public welfare. So we think that under the SAPRAC case and under the other cases that have applied the anti-SLAPP statute, it fits very comfortably within there. And again, I would point no further than Mr. Berry's own pleadings in this case. In the trial court, he has a couple of headings in his arguments. You can find them at JA 193 and JA 195. In opposing our anti-SLAPP motion, one of his headings is Ahmaud Arbery and George Floyd are murdered. The BLM movement grows and WAMU erupts. And then he goes into an argument tying together the public controversy, the public eruption of an outpouring and the racial reckoning underway as a result of those murders. The very next heading reads, African-American newsroom employees demand an end to the long history of racism and sexism at WAMU. So his own narrative, in telling his own story, Mr. Berry has placed himself at the center of the public reckoning that we're having in the United States.
I mean, that could be, but the article at issue, the focus is still on the particular article at issue, even if I realize we have to look at the broader context, but the article could have focused on that broader context, but it seems not to have. It seems to have focused almost entirely specifically on Mr. Berry.
Well, I would say it focuses on the women of color who complained about Mr. Berry's conduct, that he was dismissive, demeaned, disrespected. I'll pause there for a second to dovetail into what Judge Easterly said, expressions of their feelings, which are expressions of opinion, their subjective impressions of how they were being treated at the workplace. And there is no safer ground for expression of opinion than expressing how you feel in your place of employment. We have cited the Rosen versus APAC case in which this court affirmed the dismissal of on 12B6 grounds of an expression about coworkers. We've cited cases in West Virginia where a boss analogous to this case was called a bully. We've cited cases in California, Grillo versus Smith, where a boss was criticized for raising his voice to employees. And the court said that kind of perception very clearly falls on the opinion side of the line. And so, Your Honor, the additional independent grounds or the underlying grounds under the dismissal, after all, under anti-SLAPP law, you have to have a reason to dismiss, and then you apply the statute if in appropriate cases. The underlying reason why the dismissal should be sustained in this case across all causes of action is these employees were expressing, and the current article was giving voice to expressions of their opinions. And Your Honor, I would submit that as Judge Blackburn-Rigsby alluded to, at the largest public broadcaster in the DMV, in a setting in which Mr. Berry himself has pleaded that the racial reckoning that was underway, that he became a part of, that he was part of the problem that these employees perceived, is all part of the public interest that is being served, and that he has acknowledged himself. And so, Your Honor, we believe the anti-SLAPP statute under the SAPRAC case, under the Doe 1 case and the Doe 2 case, which was more of a fees case, but the Doe 1 case, which applied to a blog, discussions about the plaintiff. We believe that it fits very comfortably within that for purposes of anti-SLAPP. We believe that the underlying reason the anti-SLAPP should be sustained is because of the 12B6 dismissals.
Okay, can I ask you another question on that? Sorry, or well, maybe not on that, but what was the basis for attaching affidavits here in response to with a motion to dismiss a complaint? And what allowed the trial court to look beyond the four corners of the complaint here?
Under traditional anti-SLAPP procedure as it existed before the Banks decision, these cases were largely decided on the basis of affidavits submitted. And then if the affidavits didn't extinguish the cause of action as a matter of evidence, if the plaintiff could not, it shifted the burden to the defendant. If the defendant could not come forward with competing evidence to create a question of fact or to sustain their cause of action, the underlying cause of action, then the anti-SLAPP motion was denied.
But so you say traditional anti-SLAPP practice, but I mean, is there anything in the rules or case law that carve out an exception to the normal standard of how a trial court and this court evaluates a motion to dismiss a complaint in the anti-SLAPP context?
Well, yes, I would point to the Doe 1 case as dressing the table. Doe 1 was, I believe, the very first decision of this court under the Anti-SLAPP Act. And Doe 1 talked about plaintiff coming forward with proffers of evidence, defendant coming forward with proffers of evidence in order to show a likelihood of success.
But it was the CEI versus Mann case that really delved into sort of the mechanics of that and how that worked and and how it was taken from a summary judgment analysis. I guess my question is, in a case where a court is saying these statements are non-actionable opinion, not provably false, did the court have to look at the attached affidavits to reach that question?
Thank you for the question. I was going to round the bend and saying that's all vestigial at this point after Banks versus Hoffman. I think the law is clear in Banks that the court needs to look at the face of the complaint and any material attached to it. And under the opinion privilege, that's all that the court did rely on in the lower courts, and that's all this court should rely on. Opinion cases fall out on the basis of the strength of plaintiff's argument that they create. The statements themselves contain a false statement of fact versus opinion. It's a dichotomy in the law. And
Counsel,
so
can I-
that's why these cases are decided on 12b-6.
Can I jump in a little bit here? Because I was hoping you could clarify how and even whether Banks is applicable here. Because Banks said that if you go outside the record, and in this case, the affidavits, not go outside the record, go beyond the complaint, which arguably the court could have done here because the affidavits were attached to the complaint here, then how does that impact what is happening before us now in light of the Banks decision?
Footnote 27 in Banks specifically preserves the 12b-6 underlying basis as a foundation for the award of dismissal. under
And
the
here,
anti-SLAPP
since the trial
statute.
court ruled on both SLAPPs and 12b-6 basis, as well as in the second complaint, race judicata, Banks doesn't preclude or impact
It
this.
does
case in
not.
any way.
And to be frank, if Banks had been decided before we briefed the case, rather than briefing anti-SLAPP first, I would have briefed 12b-6 first. And then I would have said, because we win on 12b-6, and it's a matter of public interest that falls within anti-SLAPP, we also should be awarded the relief.
But then
Can I
if we're,
just, I'm sorry,
Go ahead.
I just want to make sure I understand, because if you go the 12b-6 route, it seems to impact entitlement to attorney's fees, which I imagine you would not be interested in relinquishing, right? Because you're not entitled to attorney's fees just on a straight up 12b-6 failure to state a claim dismissal, right? You're only entitled to attorney's fees under the Anti-SLAPP Act. So when you say Banks in footnote 27 accepts 12b-6 grounds, are you saying accepts 12b-6 grounds within an anti-SLAPP framework or
Precisely.
separate and apart from?
Yeah.
That's I'm done.
The first thing you said, Your Honor,
Okay.
footnote 27 specifically, Banks says you can't put in affidavits any longer. You can't have a discovery stay any longer. But if you move under 12b-6, footnote 27 says our decision does not affect.
It's the if you move on under 12b-6 that is hanging me up, right? Because it seems to me, I'm trying to see, is there a way to thread the needle, or do you agree to say, look, we're going under the Anti-SLAPP Act, right? We think that the Anti-SLAPP Act applies, and we think that there's no likelihood of success because these statements aren't actionable. We don't need discovery to show that. Right? We can just say, we can look at the face of the statements and say, these people are talking about their opinions and their feelings, right? They are not actionable. We win under anti-SLAPP. Does Banks have any application to that sort of analysis in your view?
Banks actually sets the stage for that exact type of analysis, and you
Okay,
articulated.
so Banks doesn't go
better than
that far, but leaves room for that analysis.
I think Banks is the first step in an argument that you would build the 12b-6. If it's granted in an appropriate case in a SLAPP case, you also get awarded fees under the anti-SLAPP statute, under the argument that you just stated. If you haven't stated a cause of action and the speech is protected under the Anti-SLAPP Act, you win dismissal under the anti-SLAPP statute because there's a failure to state a cause of action under Rule 12b-6, that they work in harmony together.
But do you even have to go? I mean, I think of Rule 12b-6 as a procedural mechanism, right? But the substantive analysis is you failed to state a claim, but it seems like that could just apply to the likelihood of success
That's
analysis.
exactly where it
under-
dovetails in.
Okay.
If you don't state a claim,
Okay.
you're unlikely to
We don't have to
succeed.
talk about 12b-6. Arguably.
Arguably, that's correct.
Okay.
If we all are in agreement, if this court reaches consensus that these statements are not actionable, as well as, there were other grounds as well that don't rely on any evidence. Res judicata would be another one, and then failure to satisfy the pleading standards for any of the individual causes of action. All of those bases in an appropriate SLAPP case do give rise to an award of fees under the anti-SLAPP motion.
I wanted to give you an opportunity to respond. Mr. Berry's counsel relies very heavily on the COLIE case as support for why this case isn't in the public realm, sort of taking us back to the earlier issue. How would you distinguish the COLIE case from the facts before us here?
In the COLIE case, the court found that the attorney was not speaking out as if you will, a spokesperson for a larger public issue, that he was simply pursuing the private interest of his client. In this case, Mr. Berry himself has placed these women's complaints in the environment of the racial reckoning at WAMU that stemmed from the societal events. It was in the context of the George Floyd murders and the Ahmaud Arbery.
How is what Mr. Berry did here different from him just defending himself against these allegations and speaking out on his own behalf? How does speaking out on his own behalf in defense of the allegations against him make it suddenly public?
Well, it's the women speaking out that's the gravamen of his case, so it's their speech.
Well, but
that
you
I'm
just talked
focusing
about
on.
him placing his statements that place this in the public realm. How are his statements, which I guess his counsel argues were his efforts to defend his claim and termination, arguably, how does that bounce it into the public realm rather than what the attorney did in the COLIE case?
Well, it all arose out of the same context. So he was reacting to the statements of the women. The women's statements were made as a result of WAMU having the reckoning that we would hope the largest largest public media entity in the district, public radio entity, would have. And because it all arose out of the context that Mr. Berry himself pleads erupted at WAMU because of.
What if Mr. Berry, what if these same actions took place at the ACE company? Just another company. Is it the fact that WAMU is a media employer that changes the nature of what happened here, or is there something else inherent in the underlying facts?
I think WAMU being who it is the reason there was pre-existing discussion in the public realm about the management circumstances at WAMU. And because it was already in the public realm, because it was already being discussed in the public realm, it distinguishes it from ACE Hardware. If ACE Hardware, National ACE Hardware, had previous
What if there were
coverage-
lots of tweets about the same conduct happening at ACE Hardware? Does that suddenly place the dispute arising from employees at any ACE Hardware store or corporation into the public realm and make it public?
I think it depends on the size and the prominence and what the company has done. Certainly, if ACE Hardware said to the public in an affirmative campaign that we are all about equality and diversity in the workplace, and there was pre-existing discussion in the public and pre-existing coverage, that might raise them to the level of prominence of WAMU in these areas. And again, Mr. Berry, we were talking about how Mr. Berry has pleaded his case. That was a large portion of the questions asked of Mr. Branch. Mr. Berry placed himself at the center of these issues. And I think he has to live by his pleadings. And this court has certainly adequate basis, not only in my argument, but in his own argument to sustain the rulings below.
Thank you, counsel.
Thank you, Your Honors.
We reserved 5 minutes for rebuttal.
And thank you, Your Honor. The appellees here are actually encouraging the court to go down a very dangerous road where someone can't defend themselves against what they perceive to be or what they know to be false accusations about them. For example, Mr. Berry is accused of causing or discriminating against women of color, causing women of color to end their employment. All he's done in this case is say those statements are false and attempted to present his defense to these allegations that these statements are false. And what the defendant is suggesting is that because he works at a company that it's a public radio, but it could be any large corporation in the United States that has embraced diversity and inclusion as a practice within the company, that because he works at this radio station, that he can't defend himself against allegations, false allegations that he alleges without risking
Counsel,
being
he
held
can't
accountable for $300,000.
He can defend himself against provably false allegations. It's just that the law of defamation says that you can't sue people for opinion. Generally, there's some exceptions, but I didn't see any argument in your brief about what those exceptions are.
Your Honor, as I mentioned before, the case of Mikulovich v. Lorraine Journals 497 US 1, 1990, it essentially says that an opinion can be defamatory.
Is this a case cited in your brief?
I don't believe it's cited in the brief, Your Honor, but opinions can be defamatory if they can be interpreted in a way to imply untrue facts and statements.
Yes, that as a broad proposition is true.
So, Your Honor, the next point is the claim of the affidavits that were attached to the defendant's motion. This definitely converted this into a motion for summary judgment. And the court relied upon, there was a lot of questioning back and forth on the affidavits, but the court relied upon these affidavits in reaching this conclusion.
How did the court rely on the affidavits to say that these statements were non-actionable opinion? Can you point to me where in the court's order it relies on those materials? I didn't see any citation to those materials in the court's order.
Well, the court's order, I believe, begins at page 493, but the court specifically said that I think the court used the language that the claims were not defamatory or opinions. The court does not specifically say exactly that this was opinion. That's one of the issues with the court's decision. There's very little analysis in the court's decision on how the court reached the conclusion that the statements were not defamatory, but we can infer.
The court says, and I'm quoting, the allegedly defamatory statements challenged by the plaintiff are non-actionable opinion. Is there something else that the court should have said?
Well, I think there's more to that sentence. I thought that there was more to that.
Well, it says non-actionable opinions substantially true and or were not made or published by defendants.
So the court is, I don't know how to read this. The court is giving us three different options. Substantially true. How can the court reach that
The
conclusion?
problem is that your brief doesn't explain to us how this statement doesn't cover the landscape of your complaints and why the court was wrong. Your brief is focused on whether or not the statements were actually defamatory in that they, harmed your client's reputation, which was not an issue, it was actually conceded in this case.
Your Honor, the other point that I'd like to raise is there's been a lot of questioning about what Mr. Berry actually says in his complaint, and that shifts the focus from where the focus should be, and the focus should be on the statements made by the women. Mr. Berry did provide his own affidavit where he disputed the allegations in the affidavits. Now, concerning the res judicata and the dismissal of the discrimination claim, we did state a claim for discrimination, but even if the court found that a claim was not stated for discrimination, the result should have been a dismissal without prejudice and not just an outright dismissal of the complaint. And I think that's the final point. Thank you.
Right. Unless there are any further questions, thank you. I'd like to thank both counsel for your briefs and arguments in this case, and the case is submitted. Thank you. All right, our second case this morning is COLIE Long versus United States. All right, I guess before argument begins, can Counsel for Appellees let me know how you plan to divide any time for argument?
Yes, Your Honor. We have agreed, subject obviously to the court's approval with PDS, that of my 15 minutes, I will take 8 and amicus will take 7 minutes.
All right.
And I'd like 1 minute to as a rebuttal time for myself.
All right. Are you ready to proceed, Counsel?
Yes, I am.
And I forgot to ask you to state your name for the record, please.
Your Honor, my name is Matthew B. Kaplan, and I represent appellant COLIE Long. What I'd like to do this morning is to address, in the brief time I have, 2 issues. Is one, the government's argument that because of their view of what the statutory text says or what it means, COLIE Long is not entitled to relief because he's been released on parole. Address that, and then also address the merits of what we think is the mistake that the trial court made in this case. First of all, on the merits, the government argues, and in our view, entirely erroneous, mistakenly, that Mr. Long is not eligible for any relief now because he's been released and consequently the case has become moot. And to get to that position, the government starts from the premise, which we agree with, is you need to look at the statute and read what the statute means and understand the statute as anyone reading that statute would understand it. But then the court says, I'm sorry, the government says that the phrase in the statute that a court, quote, shall reduce a term of imprisonment, unquote, on a defendant if certain criteria are met, and the defendant, quote, has served at least 15 years in prison, also includes, for some reason, an unstated requirement that that person must currently be incarcerated, even if the person is serving a sentence of incarceration because he's on parole. It's simply not what the statute has said. COLIE Long is a person who has served 15 years in prison, and he is serving a sentence of incarceration. If he otherwise qualifies, he is eligible to relief under the IRIS
So
statute.
counsel, I realize this is a parole case and maybe that's all you want to address, but if we put aside justiciability questions for a moment, because you're focusing on the statutory language, I assume you would not maintain that someone who has been fully released from prison, they've completed their sentence, perhaps they've completed their term of supervised release. I mean, is it your position that the statute would contemplate that they could still move for a reduction in the term of imprisonment that had been previously imposed?
No, first of all, on the issue of supervised release as opposed to parole, I think someone on supervised release is not serving a sentence of incarceration. But more fundamentally, I think under traditional notions of mootness, if someone has in fact totally completed their sentence.
Right, so
it's just clearly moot.
so justiciability questions, I still can't say that word, would apply. That's what you would fall back on there. And I mean, perhaps you would say that person lacks standing.
Right.
But as a matter of statutory language, it seems like the logical extension of your argument purely as a matter of statutory language. And I'm not saying this is fatal for you. Maybe you just fall back on lack of standing or mootness, but as a pure matter of statutory language, it seems like you would contemplate that someone who has completely completed their term of imprisonment and is fully released would fall under the plain language of the IRAA in terms of being able to seek a reduction in their term of imprisonment.
I think that's probably true if you ignore the well-established doctrine of mootness, but I think it's reasonable to understand that the council understood the doctrine of mootness and that moot cases would not be litigated under the statute. The key phrase here is has served, as the government says. That's in the present perfect tense. But in our view, the government misunderstands the tense. I mean, we think as we explain in our brief, we think our understanding of that tense is completely consistent with the Brian Garner treatise that the government relies upon.
Mr. Kaplan, can I just stop you for a minute just to clarify? So you're not going to argue on the question of mootness today? Is that what amicus is going to argue? You're jumping right to the statutory interpretation piece.
Yes, PDS has another mootness argument. The government, as I understand it, has framed even though I'm not sure I fully understand why, but the government has framed, I think, the statutory interpretation argument as a mootness argument. As I understand it, they're saying as soon as someone is released, they can't get released, and therefore our case moot. There's another argument that it was not moot when the motion was filed, and I think PDS has addressed that in the brief, and they're going to address that.
So, but you are challenging mootness on the grounds that the government's mootness argument turns on a merits analysis.
I'm sorry, Your Honor.
You are challenging mootness on the grounds that the government's mootness argument turns on a merits analysis of the statute.
Yes, yeah, and we think the government's mistaken on that, and we think in our view, the court, that issue is fully briefed, and we think the court should address the statutory interpretation.
Okay, so do you think the statute is clear on its face or and unambiguous? Or should we be looking at other factors beyond the language of the statute here?
No, I think the statute, Your Honor, is clear and unambiguous on its face, that COLIE Long is a person who has served 15 years in prison. I don't know. I mean, you can also look, if you want, you get the details of the Garner understanding of the present perfect tense. That's not inconsistent. It was totally consistent with what we're saying. And we also cite two state Supreme Circuit case that interpret the present perfect tense in the same way we think it should be interpreted in this case. But I think in our view, the statute is crystal clear, and you really got to reach to try to get to some other interpretation of the statute. And there's no reason to do that because the statute itself is clear.
Well, the statute doesn't reference parole in the explicit language of the statute. So just walk me through a little bit how you connect parole or probation or electronic monitoring, if we went further down the road, to the term of imprisonment.
Well, as a conceptual matter, a person who is, and this is different from supervised release, but a person who is on parole, like COLIE Long, is still subject to a term of imprisonment. He's serving the term of imprisonment. He is in the custody of the Attorney General, and at any moment that could be revoked, and he would go back to prison. So while he's not physically in prison, he is serving a term of imprisonment. And I would note when the statute, the IRA was initially passed, Mr. Long would not have been eligible because the statute, person who had become eligible for parole relief could not apply for IRA relief. And that was modified in the second, I think it was 2019 when the council amended the statute. So the council was thinking about, was aware that parole was out there. I guess the fundamental point we would make is that this does not apply to supervised release cases, but it applies to people who are on parole, which obviously is a diminishing pool.
Now, why would you make that argument?
I'm sorry.
What makes you distinguish between supervised release and parole for purposes of the application of this?
Because the case law, and there's maybe abundant case law at the federal level, just explaining the difference between supervised release and parole. But the Supreme Court has said, and the U.S. Sentencing Commission has said that parole is a continuation of your sentence, whereas we adopted the federal system before. Obviously, here in DC, we've adopted this new system where we have a sharp distinction between sentence of incarceration, which encompasses parole, and now we have the sentence of incarceration, and subsequent to that, we have supervised release. The two very
See,
different
now
things.
it seems like you're going back into mootness, and I know these things are they overlap to a significant extent, but from your statutory language argument, seems like you ought to lump both of those together, because he's still someone who has served a term of at least 15 years if he's out on supervised release. I mean, whether he has an interest in having his term of imprisonment reduced at that point is a separate question, but
Well, I think Your Honor, the answer to that would, as you suggest, be mootness is, you know, if you have finished your term of imprisonment, and under the new system, for example, you're serving a term of supervised release, but you finish your term of imprisonment, there's no relief available because that term of imprisonment is over. That's very different from COLIE Long's case, where
Do we
unless,
need to reach,
I'm sorry,
do we need to reach the question of how supervised release functions under this
no,
statute in this
no,
case?
you're right, you do absolutely do not need to release that.
I didn't see it briefed by anyone. And
Right.
Supervised release. I grew up in the age of parole, so I still find it very confusing. I would hate to just jump into that.
I'm just making the point that there's a distinction between the current system and the prior system, but no, the court does not need to release it, because I think it's clear that someone who's on parole is subject to supervised release. I'd like, if Your Honor, if I could just very quickly to discuss the what we think is the error of the motions court decision. This, in our view, was a close case, and I think you know, the trial court recognized that there were a lot of factors that weighed in favor of finding that COLIE Long was not a danger to the community, and that the interests of justice suggested he should be released. Most notably, I would point to you know, the testimony, which I think is probably pretty unusual in these cases, of a lieutenant in the DC jail and another longtime employee of the DC jail, who were emphatic in their testimony about how Mr. Long had been reformed and the key leadership role he played in the jail. Where we think the trial court made a reversible error is that in factor 8, one of the 8 factors that the court had to look at under the statute, that factor was the court had to look at the Mr. Long's family circumstances at the time he committed the crime. And apparently the intent was, you know, if someone had a bad family situation, that would weigh in favor of granting IRA release. But as the government acknowledges, the trial court misunderstood that factor, and it thought it needed to look at Mr. Long's family circumstances at the time of the IRA motion.
I think it's, to me, pretty clear that there was a misunderstanding there. But if we accept that the trial court discussed elsewhere in its order family circumstances at the time of the offense, why wouldn't it be harmless error?
Well, you're right, Your Honor, that the court did discuss family circumstances at the time of the offense under other factors. But where the error really is harmful, tremendously harmful to my client, is the trial court thought and understood that it was obligated to look at Mr. Long's family circumstances at the moment of the IRA hearing. And, you know, it's clear from the opinion that, I mean, it concluded correctly that he had very little or no relationship with his family. And scattered throughout the trial court's opinion are references to the fact that, you know, Mr. Long has no relationship with his family. He hasn't had a visit in, you know, he went through a 15-year period with no visits from his family. And, you know, he's got a great reentry plan, except.
Well, but couldn't the trial court have considered his current family circumstances under factor 11, which was sort of a catch-all factor, unless the trial court consider other relevant information?
I don't think so, because factor 11, you'd need to look at relevant. I think the word relevant factor is used there, or something, or word to that effect. And, you know, as
Why wouldn't it be relevant, the current?
I'm sorry.
Why wouldn't the current family situation that
Because
Mr. Long
Mr.
was
Long,
being released into be a relevant factor for consideration?
Mr. Long's situation is, I think, like a lot of people who have been incarcerated for a long time, was that, you know, he got into crime at a very young age, into drug trafficking, really, and eventually violence, because of the bad influence of family members. And in our view, it's a good thing that he does not have a relationship. And doesn't
Right,
want
but
a
you're
relationship
just
with his
arguing
family.
now about both the weight and the reading that the trial court should have given to his lack of family connections at this point, but not whether it would have been an abuse of discretion to consider it under factor 11, which then also pertains to the harmlessness of considering it improperly under factor 8. Right.
Well, I think the abuse of discretion arises from it totally misunderstood factor 8. And obviously, you know, if it's one of the enumerated factors, that suggests the court should give it significant weight. And it did give it significant weight. It said Mr. Long has a bad relationship with his family, and that weighs, and effectively it said that weighs heavily against giving him IRA relief. Our view is that this case should be remanded so the court can apply that properly understood factor. And so the court would be able to consider really whether it was a good or a bad thing that he had a poor relationship with his family, if there was any basis to consider his relationship with his family at all.
Is the relevance argument, though, tied to the specific facts of each case, right? I mean, sure, I guess you could say sort of theoretically, current family ties are potentially relevant. But if you have a situation as here, where I understand Mr. Long had a job offer, maybe had a place to live or had the means to find a place to live. If he had the job offer, then does familial support under that factual scenario become less relevant? I mean, when you're 40 years old, sure, everyone would like to have the support of your family, but kind of less relevant if you have the means to support yourself.
Yeah, I think you're right, Your Honor. And I think in really what the court should be looking at is maybe I want to call it the reentry plan, the support that an individual will have if he's granted IRA relief. In some circumstances, maybe he's got a strong family network that could help him, but that's not. I mean, the issue is whether he has a network that could help him, and he clearly did in this case. I mean, he was offered a $40,000 job, which he's, by the way, is actually working at now at a higher salary. But he had a clear plan. He had clear support for what would happen after he was released, and in those circumstances, I think his relationship with his family was either irrelevant or it should have weighed in his favor that he wasn't having contact with those people who had sort of led him into a life of crime.
All right, Mr. Kaplan, we'll allow your minute or two for rebuttal, but we'd like to hear from amicus at this time. Thank you.
Good morning. May it please the court. Zoe Freeland on behalf of amicus curiae, the Public Defender Service. I'll address the mootness and statutory interpretation arguments, and I would like to reserve 1 minute for rebuttal.
Great, thank you.
This case is not moot. Mootness is a very narrow technical inquiry that asks whether a litigant has an ongoing stake in the outcome of a case. When the relief offered by a statute can remedy an ongoing condition or injury, a case is not moot. And of course, that is true here. IRA offers sentence reductions, and Mr. Long, who is still serving a life sentence, can benefit from a sentence reduction.
Can you tell us just a little bit, very briefly, about the mechanics? If he's currently out on parole, Mr. Long, he has a life sentence. If here the sentence were reduced to pick any number, how does that still benefit Mr. Long for purposes of the IRA Act?
Any sentence reduction for Mr. Long in this case would result in less time on parole. Since the upper end of his sentence is life, if that were shortened in any way, he would be guaranteed to end his parole at an earlier date. And that's how it would benefit him. Mr. Long is still subject to the conditions of parole, and the Supreme Court has been clear that being on parole is a concrete injury under Article 3, and it affects people in a way that people can seek to have it remedied and have standing to have it remedied.
So let me ask how, I know this has been the subject of this particular case, but I think it has some relevance to how we view how far out we go. I think Mr. Kaplan has, I guess, conceded in response to Judge Schenker's question that if Mr. Long had fully served, not a life sentence, but a 35-year sentence, we would agree that he would not be eligible for a reduction in sentence under IRA because he would have completed everything. And parole, I take your point about Supreme Court precedent that says it's part of a sentence of incarceration. What about probation, electronic monitoring? Where else on the spectrum might we still say still comes within the realm of the IRA statute?
Yes, Your Honor. Well, first to Judge Schenker's point about someone who's completed their sentence, that case would be moot, as Mr. Kaplan said. So there would be no way, it would be unnecessary for the court to reduce someone's sentence and it would be dismissed on mootness grounds. But to your question about how far would a ruling like this take the court? These questions of supervised release and probation, the reason that they might be different is because the court would have to examine whether a term of supervised release or probation were part of a term of imprisonment that the court could reduce. There's no question that parole, when someone is given a sentence like 35 years to life, that is a term of imprisonment that can be reduced.
Now, we haven't, as a court, examined those other questions. Are you aware of other courts that have looked at the issue of probation, electronic monitoring, supervised release, and in this context?
My understanding, Your Honor, is no, that those questions haven't been examined by other courts, and I don't think they're raised in this case. This case is solely about whether people on parole are still eligible for a reduction in the term of imprisonment. And
But
I think
I'm not sure why we would have to decide whether supervised release, for example, is part of the term of imprisonment, because for mootness purposes, potentially someone who has their term of imprisonment reduced, even if they're out on supervised release, could have their supervised release term concomitantly reduced or be deemed to have expired if the court reduces the term of imprisonment to time served, for example. I think maybe I'm wrong on the mechanics there, but so for mootness purposes, it seems like they still have an interest that we can grant relief on. Whether they qualify under the statute, I think, is a separate question.
I think that's right, Your Honor. I was talking more about the statutory question. I think that's absolutely true that as a matter of mootness doctrine, someone in that situation would have an ongoing stake in the outcome of their case, and the case would not be moot. And I think to the statutory question in this case, the plain text of the statute makes clear that there are certain eligibility requirements. Mr. Long meets those eligibility requirements. He can benefit from a reduction in the term of imprisonment. And so there's no question that his case isn't moot and that he's entitled to a decision on the merits. And I think I want to briefly address this argument about remand to the trial court. And, you know, in the event that the court thought that the statute could be read to exclude parolees, which we think it certainly can't, based on the plain text, that would not affect the appellate relief available to Mr. Long. Under any reading of the statute in this specific case, no one is disputing that Mr. Long was eligible for IRA relief at the time he filed his motion. If the trial court erred in denying him that relief, this court can and should provide a remedy for the error. And there's a lot of case law that speaks to both this court's ability to remand a case in that kind of situation where conditions have changed, and also why an eligibility requirement like that would attach at the time of filing and would not divest the court of jurisdiction to decide a case if that condition changed while the case was on appeal.
So I realize you're not necessarily saying this, but it seems like that would suggest that your argument is that if he had filed after he had been released on parole, that we would be in a different, you would not want us to decide the same way in this case, or?
No, Your Honor. Our position is that anyone on parole is eligible for a sentence reduction under the statute. But our position is also that that question is a little bit different in this case, because here we have somebody who was incarcerated at the time he filed his motion. So on the statutory question, our answer is the same. But on this timing question of when eligibility attaches, depending on how this court chooses to decide the case, that may be something that the court has to confront.
So is the statutory language plain, clear on its face, or do we have to do more to come to the conclusion that you ask us to conclude, that parolee is eligible to seek relief under the statute?
Yes, Your Honor. The statute is plain on its face. It has two requirements: that the person committed the offense before they turned 25 and that they have served at least 15 years in prison. As a grammatical matter, and that's really where the government focuses its arguments, as Mr. Kaplan says, has served 15 years in prison.
I was gonna say you can, I'd be interested in hearing your views on the present perfect tense argument. That's
Yes, Your Honor.
the statute.
The present perfect tense, as the government acknowledges, and I think we can all acknowledge, can refer to something that happened at any point or something that continues to the present. And in this case, it can refer to either. It can refer to people who completed their 15 years in prison at some point, like Mr. Long, or people who are still in prison. And I think that the government relies on Garner's grammatical treatise, which talks about the distinction between things that when there's precision about the time, and they say if there's precision about time, then it has to continue to the present. But the government's misunderstanding what precision about time means. Precision about time means when something happened. So if you said, for example, I've been playing cards since 3 p.m. yesterday, that would have to mean that you're still playing cards under the tense, because you're talking about when you played cards. That's different than 15 years in prison, which is a length of time that someone had to complete something. And I think the example in Mr. Kaplan's brief about anyone who has served 2 years in the armed forces is eligible for a discount is a good example. No one would hear that and think you still have to be in the armed services to be eligible for a discount. So I'm not sure why this argument about the present perfect tense, which I think is pretty clearly encompassing a situation like Mr. Long's, has become the focus of this argument, but
It's, I don't know that it's become the focus of this argument, but it's certainly briefed. If we are not persuaded that the statutory language is clear with respect to this particular situation of a parolee, what else is persuasive in the legislative history? The briefing talks about consequences if we don't read it the way that appellant and amicus say we should read the statute.
yes, Your Honor. So just to the point about the text, I think one important point about that is that if the council had wanted to extend or make the eligibility requirement specific to people who are still incarcerated, it would have said that. And we can look at other places in the DC code where they did exactly that. So one good example is DC code 1301.83. That's the provision that dictates who is eligible to be attorney general. And in that provision, the eligibility requirement is that if the person is a member in good standing of the DC bar and has been a member in good standing of the DC bar for at least 5 years. So the DC council made clear that the person currently had to be in good standing with the DC bar. So I think that example really illustrates that the council knows how to make a requirement come into the present, and they didn't do that in this statute. Now, if Your Honor is not persuaded that people on parole were at the forefront of the DC council's mind when they passed this law, we totally agree with that. The DC council was primarily concerned with people who are no longer dangerous being released from prison. That's why IRA exists, and that's why they passed the law. But parolees are fairly encompassed by the plain text of the statute. And courts have said time and time again that if people or a situation are fairly encompassed by the plain text, it doesn't matter that that's not who the legislature was thinking about, as long as it doesn't contradict or undermine the statutory purpose. And here, including parolees does not undermine or contradict IRA's statutory purpose. And so our position is that the statute has to be understood and applied according to its plain text.
Thank you.
May it please the court. Mark Hobel for the United States.
Right, good morning.
You know, it was interesting to hear Ms. Friedland say that the parolees were not at the forefront of the council's consideration of passing the Incarceration Reduction Amendment Act. Certainly, the government agrees with that, but one of the problems in application of the statutory interpretation that Mr. Long and the Public Defender Service are putting before this court is if the phrase in the present perfect has served at least 15 years in prison in subsection A1 encompasses parolees who've already been released from prison, then you have to look at the statute as a whole, and subsection G is the subsection of the statute that gives priority, that puts people at the front of the line. And subsection G says, in considering applications filed by defendants for offenses committed after the defendant's 18th birthday, the court shall endeavor to prioritize consideration of the applications of defendants who have been incarcerated the longest. Again,
Why is that a problem?
have
Right.
been incarcerated the
Right.
longest.
Right, but it's endeavor to put at the front of the line, right? So please consider IRA applications from someone who has been in prison for 40 years, right? As opposed to someone who is current, you know, who was incarcerated for at least 15 years and is currently out on parole. This is just an admonishment to Superior Court of sort of how to manage your business. I really think that we need to look at the language in A, right? And I would like to hear how the government thinks we're supposed to interpret the language. The court shall reduce a term of imprisonment.
I do want to adjust the on 15 years on parole that was meant in your honor's question in
Can
subsection
we
G.
start with my question first? The court shall reduce a term of imprisonment, right? A term of imprisonment encompasses release on parole, or does the government disagree?
No, I agree.
Okay, so if the court shall reduce a term of imprisonment, and then we get to where the government would like to go, A1, which says, okay, well, you have to have served at least 15 years in prison. Why is someone in Mr. Long's position disqualified or not qualified, right? And particularly if we look at the hypothetical that was just posed to us about, you know, a military veteran getting benefits, right? A discount if they have served 2 years in the military, right? No one would think that means they have to currently be serving in the military to get the discount.
Well, the context matters. Everybody agrees on that, and the statute has to be read as a whole. But if you were to say just to an ordinary listener, familiar with the rules of grammar, because that's how statutory interpretation works. If you were to say to an ordinary listener, COLIE Long has served 15 years in prison. That person didn't know anything about this case. Would they ask you they would ask you, where is he serving? Where is he in prison? They wouldn't ask you.
We're not talking about just talking to people on the street. We're talking about a judge who is applying the statute. So a judge has someone who's saying, who's reviewing an application under IRA, where a person has been sentenced to a term of imprisonment. I believe Mr. Long's current sentence is 35 years to life, correct? It is 30, 35?
Something like that.
Right? And the judge is being asked to reduce that term of imprisonment. And the judge needs to confirm that the individual seeking the relief sought, the reduction in the term of imprisonment, has served 15 years in prison.
Mhm.
If he's done so, then he is eligible, and we go on to B and all of the factors that need to be considered under that provision of the statute.
Right,
is
and
that wrong? Or
subsection
sorry, under
C.
C.
Right,
I apologize.
right. And of course, subsection C informs the understanding of subsection A1. But look, I'm not trying to be the grammar police here on the present perfect tense, but I do want to just emphasize from an ordinary listener's perspective, if you say, go back to Chambers and say this, try this out, practice it, because Lord knows I have. If you say COLIE Long has served 15 years in prison, or the defendant has served 15 years in prison, what's the first question that comes to mind is, where is he in prison? Not when was he released? If I say I have served 10 years in the military, you're going to ask me, what unit are you in? Not when were you discharged?
I mean, look, we can all come up and the briefs have come up with examples on both sides. I mean, I can see it the other way. Someone could say prison is really a horrible situation. Ask this guy, he has served time, right? I mean, that could mean he served time and he got out and he's the one to tell you whether it was terrible or not. He has served time. I mean, anyway, we can go through this, as you said, as grammar police all day long. I think at the very least, there are arguments on both sides with respect to the past perfect tense question.
I agree with that as far as it goes. And so I think then we have to look to the statute as a whole and for specifically subsection C, which is the factors that the court must consider in order to determine whether somebody is eligible under subsection A. And
But
here
I
the court
still
needs
don't
to-
understand why the factors that we consider under C affects our analysis under A, right? Which is saying, look, you get to reduce the term of imprisonment, right? The term of imprisonment being all encompassing and encompassing parole. So yes, you might look at these other factors, which, I know you highlight one about the victim of the offense, C6, which just seems like it wasn't revised after parolable offenses became subject to IRA. But I just don't know how much that matters if the court is allowed to reduce terms of imprisonment, which encompass parole.
Well, I think the subsection C specifically says in determining whether to reduce, the court in determining whether to reduce a term of imprisonment pursuant to subsection A of the section shall consider, and then it lists the
Well,
factors.
let's
So
go with
you-
that.
yeah.
If we, since we want to move away from Judge Easterly's question for the moment, because I still want to come back to that and see your thoughts. But if we go with your reasoning that we should be focused on C,
Mhm.
I want to direct you to C3, which says whether the defendant has substantially complied with the rules of the institution to which the defendant has been confined, and whether the defendant has completed any educational, vocational, or other program. To me, you still are in the same place you are if we don't answer A. Because when you read C3, you run into this issue about which side of the present perfect tense do you fall on? Because I could read 3, as I did, to mean it doesn't matter whether the person is still at the institution. It matters whether during the detention he substantially complied with the requirements of the institution. So I just, is there any other argument other than the tense argument that you could?
Well, what I'd say
Work
is
with us
pulling
on
away from
here.
the tense argument on
Yeah.
3, because the tense argument is not, we're saying on C3, look at what the council said and even more importantly, what it did not say.
Well, I'm
It
looking at
said-
what it said, and it seems to me that what it says could encompass a parolee.
Right? Because a parolee is someone who actually did quite well while they were incarcerated, complied with the rules of the institution and got paroled. So you would want to consider that in an IRA application.
And you'd also want to consider how they're doing on parole and in the community, but it doesn't say that in C3. There's no
Well, why
text
isn't
with it,
parole some form of confinement? Right? Haven't we effectively said that in our cases? Right? A person who is on parole is not at complete liberty. We've definitely said that.
Right. In other words, you're saying that we would interpret the rules of the institution to which the defendant has been confined to mean the institution is parole and he's confined to parole. I sort of see where you're going with that, Your Honor, but I have to say that is a stretch in terms of how you'd interpret that to be.
No, I was actually reading it slightly differently.
Yeah.
As he has served 15 years. During the time he served the 15 years, he substantially complied with the rules of the institution to which he has been confined. And now he's out. I mean, so that I think you could still consider factor 3 in this analysis of a parolee who's seeking a reduction in their sentence.
You could, but interpreting, again, the council has been and has amended the subsection C factors multiple times to make clear to courts, these are the factors we want you to consider. And they've changed it because they put thought into this. And nowhere here is there any indication, as you would expect there to be, that the court should be looking at performance on supervision. That's the dog that is not barking here. I point to C5 too as another factor supporting the government's interpretation. It directs the court to consider fitness to re-enter society. And I guess as a technical matter, you could make that and you could try to apply that to a parolee, but it really is an awkward fit. If you say, we want you to look at COLIE Long's fitness to re-enter society. Well, he's re-entered society and he's been on parole for almost 2 years now. And then of course we get to C6.
But if he messed up, one could say, look, he's provably unfit to re-enter society. He needs to be stepped back from parole. In fact, he has been, and he shouldn't be entitled to IRA relief. I don't see any problem with that.
Right, and we're not addressing the situation
Well,
in
as
which
far
somebody's
as
been revoked.
dogs not barking, right?
Right.
It seems like these factors are written in a way that is broad enough to consider both performance in prison and performance out on parole.
Well, it's written very specifically and directly as to how to consider performance in prison, which is fitting of a statute that is meant to provide a meaningful opportunity for release from prison. It is
Right,
it
because
is
the
written.
statute was originally written for people who had no opportunity for release. And the council didn't go back, and maybe they looked at these factors and said, we don't need to, right? I mean, it would be pretty odd to say a trial court cannot consider an individual's performance on parole, but it seems like these factors are broad enough. And having amended the statute to say, yes, people who are parole eligible are IRAA eligible, these factors will do. Why can't we assume that that's what the council thought?
Well, then you get to subsection C6, where having amended it, they did not fix the tense in for which the
But
defendant is in prison.
What's to fix, right? I mean, if you have a person who was convicted of, some minor assault before they were convicted of murder, right? And then they're imprisoned on the murder conviction. C6 says, look, you have to consider the statement by the victim or the victim's family from the case that they're imprisoned for, not from the assault conviction 40 years ago, right? That predated the murder. Isn't that what it says?
Maybe I'm not following you. I'm sorry, I'm not following
Right,
you're
it's
saying.
a statement provided orally in writing, provided pursuant to these statutory provisions by a victim of the offense for which the defendant is imprisoned.
Right.
As opposed to any other offenses that this individual may have committed prior to the offense for which they are imprisoned.
Are in prison. That in other words, that you would not, for example, with COLIE Long, you would say you wouldn't consider the victim impact statement from the family of the murder victim because he's not in prison for that anymore. He's on parole.
He's serving a term of imprisonment, right? That's what A tells us. But what we're saying is if Mr. Long had some prior offense before the murder, we're not so terribly interested in those statements. That's not something that the court shall consider.
Right.
I mean, maybe under 11 it could, but they're not obligated to consider all the other crimes that the individual might have committed before the crime for which they are serving the term of imprisonment.
He's not serving a term of imprisonment. He has a term of imprisonment that can be reduced because if his parole is
You don't
revoked,
think he's serving a term of imprisonment?
I
I mean, the
don't know.
only reason he's on parole is because he has a JNC that says, this is your sentence, 35 years to life.
He is on parole. Parole is street time. It's in the community. And if he is revoked, he would go back to serving a prison term. On the other hand, if his parole is terminated, which could happen as early as this July, his prison sentence will terminate too. It's hanging over his head, but he's not serving
So
it.
that's,
He's
I mean, that's a different circumstance then, but whether he's serving in prison or not is one question. But I mean, would you agree that he is still subject to a term of imprisonment and that term of imprisonment could still be reduced?
Yes, I'd agree. I
Okay,
would-
so
I would
then, I mean, that seems to be relevant both to the mootness question and to the merits question.
Right. The only point I was making there is in subsection C6, when it says is imprisoned, that is talking about somebody who is currently in prison, not somebody who's on parole. And either that's a gaffe by the council, or that is a statement of the council's intent, which is consistent with the other C6 factors, which are all heavily focused on people who are currently in prison, not on parollees.
So can I ask you,
Yeah.
given that what you just agreed with, my question, and maybe I'm reading too much into it, but you started with the merits when you stepped up. Does government maintain its argument that this case is moot?
Yeah, the merits and the mootness are somewhat intermingled, because if the court agrees with the government on the interpretation of the statute as to whether Long is still eligible, the appeal would become moot because relief would be impossible.
Right, so mootness depends on us agreeing with you on the merits,
I believe so, yes.
which is
on this
not,
merits
which is
basis.
not mootness then, right? I mean, we have to decide mootness first, and if we can grant relief under some version of under our determination of the merits, then the case is not moot.
I think the court has to, I guess what I analogize it to is like if the council suddenly revoked the IRA, passed a new law that specifically specifically addressed this issue. Under this court's
That
case
would
law.
not be a mootness problem, right?
That would
I
be a
mean,
mootness problem.
what you're saying is mootness makes the relief impossible, but you agree that he is serving a term of imprisonment. So theoretically, his term of imprisonment can be modified. Now, whether or not he's entitled to it, I understand that you completely disagree that he's entitled to it, but it's not moot because he is serving a term of imprisonment. He has not completed his term of imprisonment.
For the reasons I've already stated, I disagree. He's serving the term of imprisonment. I don't disagree.
If Ira were disappeared, right? I think he could still make an argument. Wait a second, I was entitled to Ira, even though Ira doesn't exist anymore. I have that argument. It's not a mootness problem. It's a merits issue of whether or not he still gets the benefit of a statute that doesn't exist anymore.
I think this
He
court
is
has.
still serving a sentence of imprisonment.
I think this court has indicated in prior cases that an intervening law that deprives the applicant of eligibility for relief would effectively moot the case because it would make it impossible or unnecessary. And I'm happy to supplement with a Rule 28K letter as to my case authority for that.
Can I ask a question about your thoughts on the March 2019 amendment to the statute that eliminated the requirement or for someone who was not eligible for parole to be able to file for IRA relief?
So the impact of that was to provide a dual track for those like Long who were parole eligible but still incarcerated to seek relief under IRA in addition to seeking relief through parole. And he did that. What it did not do is expand IRA eligibility outside the prison walls. One question I think that just because I see my time is expiring and just to wrap up here. I know there were questions to Mr. Long and to PDS about limiting principles and how this would apply to people on probation, people on supervised release, GPS. If somebody got probation and a suspended sentence after obtaining IRA relief, could they then go back to try to have their probation terminated under the IRA and get a second bite of the apple? And my opponents essentially said, we'll cross that bridge when we get there. We have a limiting principle. It's supported by the text of the statute for all the reasons stated, which is that you have to be incarcerated to obtain IRA relief. And we don't have to take these cases of people out in the community seriatim, which is what's going to happen to the in the Superior Court. And in addressing those cases seriatim and eligibility questions, the court if you adopt the interpretation that my opponents are urging here, it's really going to be a free-for-all in trying to apply the subsection C factors, because they do not speak to the circumstances of somebody who has been out in the community and the types of considerations that a
Why can't, I mean, any thoughtful Superior Court judge consider conditions in the community under 11? Certainly that is relevant.
Right, and I think it
Right,
could
so
come in
why is
under
it,
the- right.
why is it a free-for-all, right? It just seems like any, and I think every single judge across the street looking at an IRA motion would look at how someone is doing out in the community. I can't imagine that they wouldn't,
Right.
and they would do that under 11 because it's relevant.
And your honor would be, if you want to
what's the
shove it all up
concern?
into C11, I mean, then, please go ahead and write that opinion. But I think you would be giving a tremendous, you have a statute then that would apply this dichotomy between providing a tremendous amount of guidance to the circumstances of somebody who's currently incarcerated. And then once they're paroled, it's all in C11.
Just as a policy matter, can I just ask, because I just don't understand the government's position, right? We have someone who on a normal track gets paroled, right? They're eligible for parole, they've done well, they get released. But separately, we have a statute that says, there are certain people who got convicted at a certain age, and we can look back and we can say, because of a consideration of all these factors, their sentences should be reduced, if not terminated, right? We don't need to spend societal resources either putting them in prison or monitoring them, which is quite expensive, right? These people, because of their particular circumstances, which they have to prove to us, don't need to be under a term of imprisonment anymore, or don't need to be under a term of imprisonment that is that long. Why would we exclude people who are on parole from that calculus? Why? I just don't understand that.
So from a policy perspective, of course, it's not this court's role to decide policy. It has to interpret.
No, but
the
we're
policy.
looking at the statute
Right.
to try and figure out what the statute means.
Right.
So, that informs my understanding of the plain text of the statute. And I'm not understanding the government's argument why we would want to cut our IRA relief off to this category of movement.
It's not a why. That's the policy question Your Honor asked me is, the council could have written a very thoughtful policy and statute that address the implications of providing IRA relief to people who are not incarcerated, or on parole, supervised release, probation. They could go as far, they could engage in that line drawing exercise. But they didn't write that statute. They wrote a statute that is, that is thoughtful, that is directed at the circumstances of people who are incarcerated to provide them a meaningful opportunity for release from prison. That's what they did. That's the policy here. And whatever policy, arguments there are for extending it to people who are on parole like Long, that's not this court's job. This court's job is to interpret the statute as written. But I will end, I think, on one policy note that I didn't have a chance to finish making before on subsection G, which is, again, I just want to return this court to the court shall endeavor. This is the prioritization. The court shall endeavor to prioritize consideration of the applications of defendants who have been incarcerated the longest. If I'm COLIE Long or somebody else who's been incarcerated for 27 years and then released on parole, I can go to the court and say, I get priority under subsection G because I have been incarcerated the longest, even though I've already been released.
I don't
I've
read
been
section G as giving Mr. Long any rights to demand priority. It's a directive to the court. The court shall endeavor. I mean, it's a goal setting measure, but I don't see how Mr. Long could say, hear my case first. I have a right to it under G.
It
Right?
would
I
be-
mean, it
right,
even
but you
goes
also-
on and says, except that the inability to identify those defendants shall not delay the court acting on other applications in this section. I mean, it's purely advisory. Just sort of, hey, courts, if you can, take the people who have been serving the longest terms of imprisonment first.
No, it says courts, if you can, take people who have been incarcerated the longest, which would be Collie Long would be at 27 years. Has been incarcerated, if you accept their interpretation, has been incarcerated longer than somebody who has served 15 years and is still in prison. And I understand this isn't binding, this is hortatory, but you have to believe that the council's policy here was to place aging parolees
Right.
who have already been released at the
And
front
what
of the
is,
line.
I just don't see the logic. I mean, what's wrong with that? He served 27 years in prison, was eligible for parole, got released on parole, but is still confined under the parole system. Why not say take his case first?
That is entirely inconsistent with a statute that is intended to provide a meaningful opportunity for release from prison that is the functional, constitutional equivalent of parole itself, as this court stated in the Williams case, which is the sole binding precedent on the IRS. So it's entirely inconsistent with this court's interpretation, both the majority and the dissent
Williams
judges.
interpreted a different version of the statute though, right?
Right,
Right.
right, right.
Before people who are parole eligible became eligible for IRA relief.
Right, and all, right, and I've addressed the parole eligibility point. I don't, and what I'll say is on the merits and whether Judge Leibovitz abused her discretion with respect to Collie Long, we'll rest on our briefs unless the court has any further questions about that for us.
All right, thank you.
Thank you.
All right, Mr. Kaplan, you reserved a minute, I believe, a minute or two for rebuttal.
Yes, Your Honor, I'll just a few very brief points. The government's position was reiterated here is that this is a case about the plain language of the statute. All you have to do is look at the statute and it says what the government says it says. And in fact, he urged you to go back to chambers and I guess repeat the phrase, Collie Long has served 15 years in prison. Maybe I'm misunderstanding the English language, but I don't see how anyone can say that Collie Long is not a person who has served 15 years in prison. He has. And, for that matter, even when he was incarcerated, once he passed the 15-year mark, if you've been in prison for 20 years, he would still been a person who has served 15 years in prison. I think that the plain language of the statute is, that's what we're relying on. And I think we understand the plain language correctly, and the government does not. As to the subsection C factors, I think the government said that they were modified after the initial IRA was passed. And I don't think that's really true. I think they were not modified in any substantive way. And I think that's important. Maybe you were alluding to this, Judge Easterly, is that those factors were drafted at a time when someone who was on parole could not get relief under this statute. And I don't think it's particularly unusual.
Or was it drafted, I think the language was that if they were not, the statute no longer limited relief to someone not eligible for parole, serving a life without parole sentences.
I'm sorry, Your Honor.
The March 2019 revision to the statute took out the limitation that focused the relief in this statute only on folks serving life without parole sentences. Am I correct about that?
Well, the statute prior to that amendment, Your Honor, said that someone who has become eligible for parole, yes, someone who has become eligible for parole was not limited to people who had not become eligible for parole. So as a practical matter, someone who had been released on parole obviously would have become eligible for parole. So that the consequence of the way the statute was originally drafted is Mr. Long, someone in his situation, could not have obtained relief. But that limitation on eligibility for parole being disqualifying, that was eliminated.
And you're saying that none of the changes to the factors under subsection C, there were no changes in March of 2019 to the factors in subsection C?
There weren't really material. I think there were some changes, but there weren't really material changes. And so that may be why there's not ideally, maybe they should have gone back and readdressed those factors, but I don't think it's unusual for a part of a statute to be amended and the legislature really doesn't go back to another part in which in an ideal world, it maybe it should have. And the final point I would make is it's really significant in our view that nowhere in the statute is there any reference to a continuing incarceration requirement. And one thing I think the court could look at is the title of this section of the DC code, and this is not something the code revisers came up, it's actually in the statute. I mean, the section is called, quote, modification of an imposed term of imprisonment for violations of law committed before 25 years of age. It's a modification of a proposed term of imprisonment. And that's what Mr. Long is seeking, a modification of a proposed term of imprisonment.
Thank you.
If there's nothing else, thank you.
Councilwoman Amicus, I think you reserved some time for rebuttal as well.
Thank you, Your Honor. Just 3 quick points to address. The first is to this question about applying the factors in the IRA statute to parolees. Superior Court judges actually have applied the factors to parolees in several cases, and the factors are perfectly applicable to them. Nothing the government has said shows an intent to exclude parolees from the statute. At most, it shows that the council was focused on people who were incarcerated. But what matters is whether the plain text of the statute encompasses parolees and whether they are eligible under the plain text of the statute, and they are. Parolees like Mr. Long have served 15 years and they can benefit from a reduction in the term of imprisonment that they are still serving. And just as a final point, because
What is the impact of this 2019 amendment, if any, on your argument that the statute can encompass parolees?
Yes, the 2019 amendment shows that the DC Council really intended parole and IRA to operate on parallel tracks as 2 separate things that don't influence each other. So I do think that that supports the argument that people like Mr. Long who are on parole are entitled to relief under the statute. And just as a final point about Williams, which the government raised in its argument, Williams held that IRA met the constitutional floor imposed by the Supreme Court in the series of cases outlawing juvenile life without parole. Williams never stipulated that IRA can't do more than that. And we know already that the statute does more than meet that constitutional floor. It applies to people under the age of 25, and it clearly applies to people who are continuing to serve their sentence on parole.
Can I ask, sorry, one quick question. I don't want to get too much into semantics here, but I know your position is that Mr. Long is subject to a term of imprisonment. Would you say that he is imprisoned when he's on parole?
I would say that I think there's one interpretation, so the Supreme Court has said that parole is a prison without walls, for example, but I don't think our argument rests on whether or not he is in prison, because he's serving a term of imprisonment that gets imposed at the time of sentencing.
I mean, I
even
guess
the government has conceded that that is what he's doing.
Right. I mean, the only reason I'm asking is with respect to factor 6, I know that we could look back to, I mean, it says the defendant is imprisoned, and it seems like it would say for which the defendant is or was imprisoned. If we expect perfect grammatical usage by the DC Council, which we may not, but what's your response to that?
So to factor 6, we agree with Judge Easterly's point that that factor is really about which victim's statements can be considered. Now, to the extent
Right,
that
I agree, but it would still say is or was.
to the extent that that's a clue in the statute that the DC Council was thinking about people who were incarcerated and releasing those people, we agree that that's the primary purpose of the statute. But that is not in the eligibility section of the statute. And nothing in that provision restricts who can seek IRA relief. So if somebody is meeting the eligibility requirements at the beginning of the statute in Section A, then they can seek that relief. Thank you, Your Honor.
Thank you. We'd like to thank counsel and amicus for your briefs and arguments today and the cases submitted. We have one final case this morning, Rodney Williams versus United States.
Good morning, may it please the court. Paul Maneri on behalf of appellant Rodney Williams.
Good morning.
Good morning. I'd like to reserve 3 minutes for rebuttal. Your honors, the DC Council's clear intent was for IRA petitioners to be able to file a second motion 3 years after the trial court is done deciding the first motion. That intent is apparent from 3 sources: the statute's text, its legislative history, and its purpose. First, the text. When the word final is used, as it is here, to describe a trial court order, it commonly and plainly refers to the point at which the trial court is done with the case. Second, the legislative history. The 2016 committee report contains a clear statement of legislative intent, stating explicitly that the waiting period begins on the date of the trial court's order, not the appellate mandate. Third, the IRA's purpose. The core goal of the IRA, in the words of the 2020 committee report at page 12, is to reduce the incarceration of people whose, quote, current conduct proves that further incarceration is not in the public interest. The plain meaning of the statute furthers that goal because it allows for appellate review of potentially erroneous IRA denials without disrupting the DC Council's carefully considered judgment that a fresh look at a person's maturation and rehabilitation should be available at regular, predictable 3-year intervals.
So counsel, can I ask you if a defendant's motion is denied and they appeal and we remand for reconsideration for various reasons?
Mhm.
How is it to be said that that order was final? And what's its status on remand then? Is it your view that a new order, completely new order comes out on remand? And does that restart the clock, or is there a new order that gives rise to an additional ability to file a second motion?
No, I think that first order that creates appellate jurisdiction in this court is final in a broad sense of the plain meaning of the word final, meaning that the court of first instance is done with the case. That's a broad, plain meaning that results in several legal consequences, one of them being appealability, another one being claim preclusion. All we're suggesting that is that in this statute, a third consequence attaches, which is that the waiting period begins. And I don't think there's any ambiguity on that read of the statute that it would be that first order denying or granting only in part that has those consequences. And so then if there's another order after a remand, that really doesn't affect the question. And I don't think it sort of injects the uncertainty that the government tries to suggest that it does.
Would it matter the nature of the remand? Right? I mean, if we remand because there's been some sort of legal error, the court failed to consider factors, presumably the Superior Court is looking at the same record, right? That they looked at when they initially issued the order. And so if the court is looking at the same record to now conduct the analysis, one could see the sense of saying, okay, well, the 3-year clock starts from the issuance of the first order before it was appealed, right? Because the record hasn't changed, and the whole point of the 3-year interval is to allow new facts to do, the individual to rehabilitate themselves more and gain, more evidence to present to the court. And if the record's not going to change on remand, right? What if there were a circumstance where we said, actually, we're remanding the case? I don't know what circumstances under which we would be permitted to do this, to say, we want you to take new evidence up to For example, in the family law context, right, when we're looking at the best interest of the child and we have some sort of consideration of custody, oftentimes we remand and we say, look, the best interest of the child is the best interest of the child here and now. So when we remand this to Superior Court, you're not bound to the old record. You can look at anything else that's been going on with the child because we care, right? We don't want to set this in amber and just consider some facts from a long time ago. So would it matter if the trial court were considering an expanded record? on
No,
remand?
it would not. And the reason it would not is because all we're trying to do here is determine the legislative intent of the words become final. I take your honor's point that that might affect sort of the purpose of what that is trying to do in the statute, but I think the words are clear from the dictionary definitions that we cite, from the many other readings from Superior Court judges in this court in Williams, and even the government in Williams, that the words become final have a clear and natural meaning. They refer to
But I
that.
guess my question is, in that scenario, which I accept like may be a limited scenario, right? And a small sliver of cases. I wonder if the order has become final because new facts are being taken, the record is being expanded. And I thought you might say, look, if the record is the same, you stick to the initial order. But if the record is augmented and new evidence is presented about things that have happened with the movement in the last 3 years, then this is just a continuation and they get the benefit of this new information for their first IRA motion, right? And so now with that benefit, maybe they'll get relief, but maybe they won't. And then the 3-year clock starts.
I think from the ex ante position of not knowing what the court's remand order is going to look like, there needs to be some predictability. It's clear from the council's intent that this would function as a regular, predictable 3-year interval. And so in order for that to occur, one would need to know at the time that the trial court is first done with the case, before the appeal has had a chance to play out, when everyone understands that there is a sense of finality at that point, that, okay, the 3-year waiting period has begun. Now, I take your honor's point that if the court if the appellate court remands and for whatever reason instructs the court to expand the record and look at updated evidence, then the petitioner should get the benefit of that. But I think that still makes sense because then you're restoring that person to the position that they would have been in had the trial court not initially erred in that decision of the first motion. And so you're saying you can have your first motion considered anew. We're not going to penalize you for being wrongly denied your first motion and taken an appeal to vindicate that. You don't have to choose to file a second motion as early as you could have. Maybe strategically it makes sense for you to litigate the remand, see, based on the updated evidence, what the decision is, and then, the statute's provision allowing you to have regular, predictable 3-year intervals is not wiped out for you. But again, I think we're sort of far afield from the core question before this court, which was what did the DC Council mean and what was its intent when it enacted a law that said that a second motion may be filed 3 years after the order on the first.
Council, we certainly have lots of examples of legislation that would support your view that it becomes final when the trial court's order is entered. And we have criminal statutes, we have statutes in the civil context that say that this relief becomes final. Divorce cases, once the time for appeal has run or the appeal has been finalized. We have that language built into criminal statutes as well. It wasn't included here. I guess, how do you respond though to the government's argument that becomes final? Because the legislature could have said just as easily upon the issuance of the trial court's written order.
Right.
Period.
Yeah.
But they didn't say that. They added the language becomes final. So what does becomes final mean here? It doesn't mean it it seems like it must mean more than an oral order given in the proceeding being translated to the written order that's required under the statute. But what more would that be?
I think becomes final is a typical way of referring to the point that many other judges have understood the statute refers to, which is when the trial court is done with the case. The government
Based on what? I
acknowledges
know,
that.
no, we have sort of the Black Law Dictionary definition.
Yeah.
Is there anything else that supports that reading?
Yeah, just I think plain meaning, which you can see in the way that the Supreme Court in the Clay case that the government relies on describes when a federal judgment typically becomes final for appellate review and claim preclusion purposes. It says when that court is done with the case, when it has nothing left to do but execute the judgment. That's not a technical definition that the Supreme Court is citing. It's just a sort of plain meaning, common sense, and we know that it is both of those things from the way that this statute has been read when this question is not directly being raised in a technical sense, right? Every other Superior Court judge that has looked at this language with a plain eye has understood it to mean that a second motion can be filed 3 years after the written opinion on the first motion.
Right, we're looking at it anew and trying to definitively interpret what the language should mean. And I guess one of my questions is the language really plain, or do we have to look further at the legislative context, at the underlying intent, at any potential consequences? If we do, what would you say about what the legislative intent shows us, what the underlying context of the statute tells us, and what any consequences, how they weigh?
I think the language is plain, and the court should look at those other indicators of legislative intent. And when it does, you're met with clear evidence that the DC Council understood and intended for these waiting periods to function as regular 3-year intervals. Again, I'll point the court to the 2016 committee report where the committee said in unmistakable terms, a second motion may be filed 5 years after the order on the initial application. And by saying the order on the initial application, there is no way to read that the way the government does to say that it's the appellate mandate that controls for the purpose of the waiting period.
Right, but that just begs the question then, why change it to becomes final?
I think as a practical matter, that language is taken from a federal piece of legislation. And as I said, I think the phrase becomes final is a common way of referring to the same thing that the committee referred to in its committee report. And it's not unusual for a statute to use sort of legalese and then for the legislative history to illuminate the meaning of that legalese in plain English. And I think that's the situation that we have here. I would also point out that, to the extent that the statute could have been written in a more direct way, first of all, that doesn't tell us that it was written in an indirect or unclear way. And second of all, I think that logic sort of cuts both ways and actually is more reason to doubt the government's interpretation than it would be ours, because we know, as Judge Blackburn-Rigsby was saying, what it looks like when the DC Council legislates and wants to refer to a type of finality that occurs after some stage of the appeal. They say that expressly, they say that explicitly. They say it in the case of Superior Court decisions governing civil tax cases. They list out the 4 points that one might look to for stages of an appeal where an order could become final. So the absence of that language here, I think, shows you that if the council had meant what the government suggests they meant, the statute would look a whole lot different.
Counsel, I don't hear you making the argument that I thought I saw in your brief, which was to rely on 24403.03B4.
Yes.
Right, where the statute says, look, you have to issue an opinion in writing, but you can go straight to sentencing after granting an application. So if you have a hearing and you think, yeah, this person should be released, right, then, or have their sentence reduced, to time served or something less than that, you can immediately re-sentence them there. So, why wouldn't the become final sort of, look, courts say all sorts of things from the bench, and then the proof is in the pudding when they actually put something down in a written order.
Yeah.
And if you're not happy with it, you appeal from the written order. We have all sorts of cases that say, look, what the court said from the bench, particularly where there's a statutory requirement that you have a written opinion,
Yeah, I think that's.
is a non-final order, right?
Yes.
We are not going to allow you to appeal from that case.
I think that's absolutely right. And I would add that the language allowing a trial court to proceed immediately to sentencing at the hearing was added in 2019, which is just further evidence that the council understood that there are multiple decision points the way your honor is describing. And so the language becomes final, sort of helps to clarify, okay, in the event of multiple orders, which it's clear from the face of the statute that that's a potential here from the statutory scheme, which of those orders controls, it's the written one as your honor is describing. Let me just briefly address, I think, Judge Blackburn-Rigsby, you asked about consequences and purpose, and I think those also confirm that the plain meaning of the statute that many other judges have already read is the correct one, because this statute, as I said, is all about reducing unnecessary incarceration. Mr. Williams' interpretation would further that purpose because it would allow for people to seek appellate review of an initial IRA decision that may have been erroneous without delaying, without disrupting the carefully considered judgment that 3 years is a meaningful period of time in which a person can mature and rehabilitate, such that we would want courts to be taking a second look, or in this case, a third look at their sentence after that amount of time. Conversely, the government's interpretation, if you would accept it, would penalize people who appeal by disrupting that predictable scheme, adding unknown months and years to the wait before filing a second motion for no good reason and with no whiff of evidence anywhere in the legislative history or from the text that the council intended a result like that.
So if we're talking about consequences and policy, bringing us full circle to one of my first questions to you. If under your argument, going back to the remand for reconsideration and a new order reflecting what our mandate to the trial court on remand, is that the defendant's second bite at the apple? And now they've got, I mean, they're limited in the number of bites they can take, right? So now they're down one. That
No.
would counsel in favor of saying that the first order is only final after appeal, and now they've got more bites.
No, I think it's consistent with the purpose of the overall purpose of the statute to sort of provide opportunities for relief, to say that if somebody's first opportunity is infected with error, they get a remand, you're still technically on your first motion. That doesn't change the fact that the initial order denying that led to this court's review and that led to a remand became final when the court was at first done with that motion.
Right, I know, but or do you agree then that that counts as your first motion? And whatever the court, if the court issues a second order on remand and you then, whatever you file at that point is your second motion?
No, that would be a remand on the first motion that's not taking up another opportunity that the statute provides.
And
No.
doesn't, in your view, reset the clock because the clock was set from the initial order that became
Right.
final that
The
led to
clock
the
starts
appeal.
running once the triggering event happens. You can't look back and see, did the clock start running when the order became final, depending on the nature of the remand. I think that would sort of create another unpredictable feature of, and somebody wouldn't know whether to appeal because the nature of the appeal and the nature of the appellate relief that they may or may not get would have this very consequential effect on when they can come back to court with updated evidence. of their maturation and rehabilitation. I think the government's interpretation would lead to other arbitrary, irrational results that the council simply could not have intended. Not only would it disrupt this sort of carefully considered judgment that 3 years is the appropriate amount of time to have subsequent looks based on things like the age crime curve, which the council talks about as a extensively documented phenomenon that people desist from crime as they age, but also the special capacity of young people to rehabilitate. In addition to disrupting that scheme, the government's interpretation would inject arbitrariness and disparity between IRA appellants, because the ultimate waiting period that someone would have to wait in between their first motion's denial and their second motion's consideration would depend on things like this court's caseload, how long it takes to schedule an oral argument, the strength of their appeal, and you'd be left with the sort of odd scenario where somebody with a really close case and a difficult appeal to resolve is going to have a longer waiting period than somebody with a frivolous appeal.
I mean, I'm not saying this defeats your argument, but you still have some of that even in the trial court, right? I mean, a trial court might take months to write their opinion and enter their order.
That's true, but I think the difference is, as you said, you're talking about a smaller scale where the disparity is going to be weeks and months rather than months and years. And second, it doesn't affect a decision of a litigant the way the government's interpretation would. If you put yourselves in the position of somebody who's just had their first motion denied, and they're trying to decide, what am I going to do? Do I want to appeal or do I want to start the waiting clock? That's the position that the government's interpretation would put people in. And there's no indication that the DC Council intended to force such a choice on people. And everything about the statutory purpose here suggests that they would not have abided such a choice. So if there are no further questions,
All right.
thank you.
Thank you. You reserved a few minutes for rebuttal as well.
Good morning, and may it please the court, Eric Hansford for the United States.
Good morning.
This court has before it two possible interpretations of the statute, and the defendant's interpretation doesn't work. An order that is denying IRA relief is already going to be final. So there's no reason for the council to separately specify that it become final at a certain.
What about in my scenario where I have an IRA movement? We have a hearing. They're asking for time served. I say, I'll knock off, 5 years of your very, very, very long sentence. They're obviously not pleased with that. And I just say that in court, right? But I have to, under the statute, that's an order, right? I can say, I'm ruling now. I'm ruling from the bench.
Yes.
And this is all the relief I'm giving you, and it's not what you want, right? That's not a final order under the statute, plainly, because I have to write it. I have to issue a written opinion under the statute. I'm statutorily obligated to.
So I'd say two things. First is that the language of becomes final came in the 2016 original version of the IRA. At that time, in subsection D, the only orders that were covered were orders denying IRA relief. So in the court's hypothetical,
Right, but I'm denying the relief, right? The relief requested was time served, and I say, I'm not giving you that.
No, Your Honor. What you are doing in that scenario is you are granting in part and denying in part, which is what was No. It's separately added. Like, this is an amendment that the DC Council makes. They separately add that requirement. So you are not in that case denying relief. You are granting in part and denying in part, which is separately put in subsection D. That's in the 2018 amendment. That language is specifically added. So in the court's hypothetical, if you are denying relief to an IRA applicant in that scenario, there is nothing else that's going to happen. At that
Right,
point.
but I could still change my mind.
So
Right, I could rule from the bench and say, I'm giving you nothing.
So
Right.
if you are,
And then my final order in the written order could be, okay, fine, I'll give you 5 years off so you become
So,
parole eligible.
I don't think you can change your mind if you say, I am denying relief. The normal rule for sentencing practice is whatever
Do you
you
think a
said.
Superior Court judge cannot rule from the bench and then reconsider sua sponte and say,
No.
you know, I really gave these factors under C, these particular factors short shrift. I will, on further reflection in my written opinion, say something slightly different than what I said from the bench.
So I still haven't gotten to the second part, but just on the first part, in the standard practice, if you are imposing judgment, is once you make the oral judgment, that is final unless you indicate, unless you indicate otherwise. And that's what the Newman
No, but
scenario is dealing with.
I intend for my ruling to be final.
So
I
if,
think that I've decided it. I go back, come off the bench, talk to my law clerk and say, my law clerk says, Judge, you know, I think we need to look at this again. And I do. And then I say, you know what, I'm gonna modify this in my written decision. Right? I don't understand why it becomes final, right? The oral, whatever I say from the bench is legally not operative under the statute, but it is an order, right? It's not final under the statute, and it's certainly not appealably final.
I guess I disagree with all of those premises. I think if you are saying I am ruling on this motion and here is my ruling, then I think that is a final.
And you
ruling.
think this
And
court could then review that?
this court
oral
could then
ruling?
review it and would send it back and say, you needed to do a written order. That's what the statute requires. But
I think we would say this is a non-final order. We do not have jurisdiction to hear this case.
so this court,
And don't
case-
come to us, IRA movement, appealing this non-final order. The court is statutorily obligated. We might even have, you know, our legal staff call over to the court and say, hey, where's that written order? And the court would say, well, I'm working on it.
So,
right?
so this came up in Newman and Nix. You don't have to go fully hypothetical here. This came up in Newman and in the case that's cited in the briefing, which we discussed. And what this court said is that was a tentative, non-final oral decision. That was not a final order because the court said in that case that I'm going to issue a written order.
Right,
And
so
what
it
Nix,
became final with the written order.
well, because of how that was presented in that case, which was, I am going to be denying this. If you say, I am denying this, then that is the order.
I mean,
but-
Newman is like one unpublished order from a
The-
motions panel, but and it doesn't have that analysis in it, but I'm struggling to see why the becomes final language just doesn't have any meaning to the government.
So I mean,
Other than
be-
requiring finality after this court issues the mandate in a case.
I mean, it's for what I've already said, but the second part of that answer is that the bigger problem that you have in this case is that there are there can be from a single application for IRA relief, multiple orders that are denying relief. And the statute contemplates only one order denying relief. So that's what Judge Schenker's questions were going to. When you have an order from the trial court that denies relief, goes up on appeal, this court says, remand, reconsider, there's going to be a second order denying relief, even though the statute says
Right,
there's
and so
only.
this gets back to my question. If that second order denying relief is looking at the same record, right? So say the court issues an order in 2020, right? And it gets to us and we issue our opinion in 2022 and it finally goes back for remand in 2023. But we have not told the Superior Court that they can look at anything new factually. Why would it make sense to say that any ruling on remand that the clock has to start there as opposed to the record that the court considered, which is frozen, right? right?
So
We don't consider new evidence.
I-
And if we're saying, look, on this record that we have on appeal, you didn't apply the factors correctly. Go back and do it again on the same record. Why wouldn't we say the clock under the statute starts with the first order when it became final?
I would be very surprised if PDS's position or this court wanted to take the position that normally in that case, you would not be reopening the record. The normal default rule, I haven't looked at this in IRA cases, but the normal default rule in sentencing cases is that when you have a sentencing, it goes up on appeal, it comes back down. The sentencing court does look at new new information that's come since the sentencing. I don't have it off the top of my head, but there's a maybe 2012 Supreme Court case that says that is supposed to be the rule. So I'd be awfully surprised, just as to the court's premise, if the rule were the record is closed, we're only going to look at your performance in 2019, even though it's now 2022. Instead, I would think the default rule would be supplement with what's been going on since then so that I can reconsider. But
Maybe that does become the rule, but what's the problem?
So, but the problem is that what Williams explains, that these second multiple looks are doing, or what the point of this multiple 3 chances process is that you are giving the defendant a chance to show rehabilitation and maturation. And how you are doing that is you are getting an order. So for example, in this case, the trial court comes out with an order that says, look, defendant, you haven't had a very good prison record. You've also been kind of falsely talking down your crimes, and you haven't taken any sex offender focused kind of rehabilitation courses, even though you had all these horrendous crimes. That really only emerges from the reconsideration order. It's not
Right.
clear.
Can I just ask one more follow-up question? I don't understand, right? Like, so you go back on remand and the movement tries to put in new information of, yes, I have been doing the requisite counseling. I have taken this many more hours of, classes, what have you. And so, and in the meantime, because of how long this court took to resolve their appeal, has filed their second IRA motion. Maybe it gets consolidated. Maybe the first one moots out the second. Why should that alter how we interpret the statute?
So I'd be awfully skeptical that you could file a second petition while the case is on remand or is on appeal here. I think under Coinbase, normally this court would have the jurisdiction over the sentence. So it'd be
Under what? I'm sorry.
under Coinbase, which we discussed in the Supreme Court case from this year.
We wouldn't have jurisdiction over it after we remand it.
Not
If
once
we
you remand,
remanded the case.
but I don't think a defendant would be able to file a second IRA.
Well, I mean,
Why?
our
I-
appellate jurisdiction divests the trial court of jurisdiction, but I don't think it divests a party of the ability
Seeking
to
an-
seek relief.
I
To seek additional separate.
perhaps fair enough,
Right.
but the trial court couldn't be resolving. Fair enough. The
What,
trial
I
court
don't
could-
even understand that. I mean, in the family law context, again, right? We have people come back and say there are changed circumstances. And now I would like you to modify custody based on these circumstances. And even if we have their appeal based on a record from a different point in time, the trial court can resolve those. And sometimes those cases moot out our appeal.
I
don't
can't speak to
understand
the
why
family.
that would be a jurisdictional problem for us, for the Superior Court, just because we have an appeal from a record at a different point in time.
I mean, we discuss it in our brief. We cite the Coinbase case from the Supreme Court. This is on 40 of our brief. Coinbase goes into this. This has to do with the Griggs principle. There's a whole kind of set of case law about this. I don't know how it interacts with the family law context.
Can I offer a more mundane example of what could be the gap between the order and becoming final, which
Sure.
is, let's assume that we do have some sort of order, whether it's oral or even written. We often have a gap between that, even the signing of it by the trial judge and the entry of it, right? And in a lot of cases, timing periods are judged from when the order I mean, the signing of the order is not necessarily the finality of the order. It's usually the entry on the docket, at least in certain circumstances. I think for timeliness of notices of appeal, it's the entry on the docket. So, I mean, could that be the becomes final gap?
I don't think it's. I guess none of those have come up. None of that has been pointed to as a circumstance that's occurred here. And I think you still have to, even if you are coming up with an explanation for how becomes final is somehow doing some minimal work. If it means appealably final, you still have this multiple orders problem that's inconsistent with the statute and that the
I
defendant.
wanted to press you on this, what you call the multiple orders problem, because I'm not sure I see the problem. One of the problems I have with the proposed interpretation that the government is offering, it seems like it forces the defendant to have to choose. Do I pursue an appeal on the merits of the trial judge's decision, or do I lock in the time now so that in 3 years from now, when the trial judge has issued a ruling I may disagree with, I still can petition again under IRA? I don't see how those are inconsistent. I mean, waiting for the trial judge waiting for the appeal to wind through the process. I think one of the arguments was in hopes of getting some additional guidance. That may not come to fruition. The appeal may be decided on a different ground, or within that 3-year period, new circumstances have arisen that the defendant may want to choose to highlight in their second petition. If there's a remand, again, I don't see the problem, because what we're focusing on is how do you count the time within which a defendant can more predictably count on filing their second motion for IRA relief or their third motion. I think if we base it on appeal rights, one defendant could have a 3-year sequence between when they can file for second motion for relief and resentencing. Another defendant could have a 5 or 6 year sequence. If we're waiting for a remand and then a decision, it can be longer or shorter. That seems to muddy the waters for the underlying purpose of this particular statute. So I guess when you keep referring to multiple orders, I don't see how that impacts the timing piece of the 3 years from the date of the order to when you can seek subsequent opportunities to reduce your sentence.
So the problem is that what the statute says, the statute contemplates one order that is denying relief. So the statute says if the court denies or grants only in part the defendant's first application under this section, a court shall entertain a second application under this section no sooner than 3 years after the date that the order on the initial application becomes final.
Right. So again, I don't see how that language is inconsistent with reading the statute to mean the date of the trial court's order denying in part or in full relief and reduction of sentence.
And the problem is, which you could have easily imagined in the first appeal here, is the trial court goes and denies the defendant's motion. It goes up on appeal. This court sends it back down. Well, so
maybe. So your interpretation seems to presume that the defendant must appeal. Suppose they decide not to appeal and just wait 3 years, thinking that that may come sooner than having to file an appeal, go through the appellate process, wait for the case to come down, and perhaps get the relief that they're seeking.
So our position does not depend on whether the defendant appeals. Our position offers a clear rule for all cases. But this court has to have a rule and an interpretation of what becomes final means that's going to apply to all cases. And so the problem is in the scenario where the defendant does appeal or successfully seeks reconsideration, the trial court has to issue a second order. there's going to be a second order that is also going to be denying relief or granting in part relief. So if, there's the initial order, it goes up on appeal, this court sends it back down, the trial court again denies, that's a second order.
Right, no,
And
I
so,
understand what you're saying, but it seems to me that that kind of cuts against your argument, because if you base it solely on the trial court's initial order denying or denying in part relief, that applies to everybody. If you base it on these contingencies of appeal, of a remand, of a mandate, that's when you get into different outcomes, different rules, and looking at different orders. If we just limit it to that first
But-
order.
but the statute doesn't say first order, it doesn't say initial order, it says the order. It contemplates one order. It doesn't, so you.
It says the
this-
order
this court-
denying or in part or in whole the reduction of the sentence or the relief requested.
But this court would then have to basically insert language into the statute.
Well,
This
we've got to
court-
insert a lot more language into the statute, I think, to get to the interpretation that you're seeking.
No, our language is, so I think it's important that this court look to the COLIE decision from the Supreme Court, which discusses what it means for an order to be final. And it says there are these two interpretations, which is the interpretations you're hearing this morning. It can be final for purposes of appeal, meaning when you can take the appeal, or it can mean the appellate process is run and it has decisive effect, determinative effect, everything's done. Those are the two possible interpretations. Clay says in the post-conviction context, which we are clearly in, the normal meaning is that second meaning, which is what the trial court said here and what the government is saying here.
But the
Which-
government isn't espousing a clay-based argument that this order becomes final after the possibility of Supreme Court review is exhausted, is it?
So
I thought the government's position was once the mandate issues from this court, but that's not consistent with Clay.
I mean, I think we have been defending the trial court's decision. Frankly, I don't think we thought through whether or not it would make more sense to have it run through the time for filing a cert petition. And it may well be that it would
Why,
make more
why
sense.
would that make sense?
Well, because the question is whether or not everything's settled or not. Because once everything's
Why
settled,
is it-
that's when.
Why is the concern whether everything has been settled and not the concern about what has this individual been doing for the past 3 years since the trial court, the finder of fact, ruled?
Because what we are trying to do, so let me give the example from this very case, from this appeal.
I mean, it would help me actually not to talk about specifics in this appeal. I'm just very curious to know why the government thinks that our focus shouldn't be on the individual and what they've been doing for the past 3 years since the trial court, the finder of fact, looked at the record materials that they submitted, and should be focused on sort of
Because
whatever this court does or doesn't say in an appeal that may or may not be taken.
Because the point of these IRA 3 chances is to give the defendant a chance to, it's a conversation with the trial court, and it's a chance for the defendant to respond to what the trial court's saying he needs to do. And you can see that here when you look back at the first order that's denying relief, there's very little information about what the defendant should be doing in order to possibly have a second successful application. In the reconsideration order, there's more information about that, which is emphasizing that he hasn't taken these sexual offender kinds of classes. He hasn't, he has these bad
Well, that
prison records.
certainly would help. I mean, if a defendant decided to wait to see what the Court of Appeals said or see what was said on remand, but I don't think it's required here. I think they can certainly, with counsel, review the same factors 3 years later and demonstrate significant changes that may support a reduction in sentence when they file the second time, completely apart from what's said or not said on remand or what's determined on appeal. I mean, it
Let-
seems to me that there's nothing I see in the statute that requires the defendant to choose one avenue or the other. It seems to me that it could be open. They could file and appeal and have the 3 years run. And if that runs faster than the time on appeal, then they go forward with what information they have to demonstrate changes in the defendant's behavior. And I think the focus that the government has is what this court may or may not do, not what the trial court has said, not what the factors say, and not what the defendant has done, which is what we're supposed to be looking at to see whether they have demonstrated that they can be released sooner into the community or that their sentence can be reduced earlier for their behavior, their growth, their maturity, all of the factors enumerated in C.
I'd say it's an awfully defeatist approach to appeals that PDS is pushing. If all we're seeing them as is a delay. The idea of the appellate process.
No, I'm
taking-
not saying, I take your point that after an appeal, additional guidance or perspective may be provided in the appellate decision or in the remand decision, which might be nice and which might be helpful to the defendant, but not necessarily, it could not necessarily the sole basis upon which they have to show that they've changed, been rehabilitated, are no longer a danger to the community under IRA. So I don't see these two things as mutually exclusive.
So I think it is a standard feature of
Many legislation, pieces of legislation that specify, as I said earlier, in the criminal context or in civil, family, other contexts, that the decision is final upon appeal, upon pursuing the appellate rights, upon the time for appeal expiring. That's not in this statute, but it is in other statutes.
No, I mean, Clay is dealing with 2255 in the federal statute, which just says when the judgment is final. It doesn't say for purposes of appeal. That's why Clay comes up. I think Clay is awfully instructive here because it's the Supreme Court looking at this very word final. And so, you know, the Black's Law Dictionary isn't helpful in that context because we have the Supreme Court talking about this very scenario. But let me offer another kind of.
The issue in Clay is not rehabilitation, is it?
Certainly the issue in Clay is not rehabilitation.
And
but-
that seems to be the whole ballgame. I mean, that is what IRA is about. Say you have a case where a trial judge says, you know, look, I think it's really close, but, you know, if you had 1 or 2 more years of, you know, coursework or volunteering or whatever, like, you know, I might grant, but you know, you're not quite there. It's really close. And here's my legal analysis, which is completely wrong. Right. And so then the movement has to decide, well, do I go take an appeal to ask the court to correct this completely wrong legal analysis? Or do I file my IRA motion? Do I not take the appeal because the court said, if I just have 1 or 2 more years of rehabilitation, it would grant, right? Like, that doesn't make any sense.
I mean, so one, I'd say the hypothetical is a bit hard to understand because the court is allowed to grant partial relief to say, I'm going to lower
In
this.
my
So,
hypothetical, the court grants
Okay,
no
so-
relief.
so in that case, this court has been handling the IRA appeals expeditiously. They're often placed on a
Do not-
quicker
we-
calendar.
We do not do the same thing that we did for compassionate release motions, which is decide them with summary disposition.
I mean, here, for example, this appeal, I think it was filed over the summer. And now we're hearing argument on it now. I mean, there are ways you can get much quicker
Yeah, if the
consideration.
appeal
but-
decision comes out within 3 years, then none of this really matters. But so I think we're all here on the assumption that some appeals might take longer than 3 years to be resolved.
So I think if the appeal takes longer than 3 years, as I said before, I don't think the trial court can do anything as long as the appeal is pending. But let me.
And that's based on Coinbase.
Coinbase, which is based on the Griggs principle, which are,
Right.
I mean,
Coinbase is a case where there's an interlocutory appeal because as to whether or not the claim is arbitrary. I'm not going to be able to say that word, just like Judge Schenker was struggling with justiciable. So where there's a question of whether the case should be subject to arbitration. That just seems completely different where we have a moving factual base about whether or not this person, right? The issue in any IRA case is this person eligible for release right now, right? And so time A, that case is different than whether or not they're eligible for release at time B, 3 years hence, whenever you start the clock. They're two different cases. Right? It's not the same case.
I mean, so it's not just based on Coinbase. On page 40, what we quote is from this court's decision in Bell, which is a criminal case, which says once appealed, this court is said to be in this court. And in that circumstance, the trial court may not vacate, amend, or reduce a sentence. That's the language in our brief. But I think going to the court's earlier question about IRA's purpose, subsection D is running directly contrary to the notion that we are supposed to give people as many chances as quick as we can to gain release. What it says,
I mean, it's not as many chances, right?
Right.
The movement has to be judicious. They only get 3 chances, so they need to think very carefully. But why should we tell them that if they have 3 years of truly stunning rehabilitation from the time that the Superior Court issued its initial order, they can't file because this court is still considering, because of backlogs and, requests for additional time and briefing, like we haven't issued our order on the first appeal.
So I'll loop back to the statutory language for why you can't say that in a second, but just in terms of purpose, subsection D in saying you have to have a 3-year waiting period is awfully unusual. I'm not aware of another statute that says there's a minimum waiting period before you can take some other action in this court. It's frankly somewhat paternalistic to have that sort of waiting period. And the point of the waiting period, I think it's clear, is to protect defendants against their instinct to use up all their chances at once. And what it's doing is it's saying, look, we understand you're sitting in prison. You might want to use up all your chances all at once, and then you'll be out of chances. You can be imprisoned at age 18, apply at 33, apply again at 36, apply again at 39, and then you're stuck serving your life sentence. You're out of your IRAA chances. And so what the statute and interpreting the statute in the way that the trial court suggested, which is what we're defending here, is consistent with, is offering this longer path, seeing the IRAA.
Well, offering the longer path seems to be inconsistent with what the language of the statute says. The language says 3 years from the date of the initial order.
It doesn't say initial.
It says initial, 3 years from the date the initial order becomes final. That's what it says.
Right. Well, no, it doesn't say initial order. It says the order.
It does.
Order on the
It
initial
does.
application.
Order on
It
the
says-
initial application.
Right, but that's important. It doesn't say initial order. It says there's one.
3 years from the date that the order on the initial application
Right.
becomes final.
So order on the initial application
Okay.
is just one order.
Right.
But there can be, if you have an initial order, then it goes up on appeal, then it comes back down, you're gonna have a second order.
Right, but they would have already,
But it doesn't say initial
would have-
order.
already taken their opportunity based on the date that the order on the initial application became final, plus 3 years. And if they want to use that as their second opportunity to file the next application, I think the statutory language supports that.
So this court would have to insert words into the statute
No,
to have
I
that.
just read it like it said, and it says 3 years after the date that the order on the initial application becomes final.
That
So
remand
if
order,
they choose to make that the date that the trial judge issued their order, then that's the order that they use to calculate their 3 years. If they choose to wait for the remand order or the Court of Appeals order, I don't think the statute requires that
So-
as it's written here.
so the remand order is still an order on the initial application. It's still an order denying relief on the initial application. So
Okay,
this,
so is the first order from the trial judge.
right.
I mean, I think we
but
can keep debating this. I
but-
see your point, but I'm not sure I'm persuaded by that particular point.
But the means there should be one order as opposed to multiple orders. And
D seems to indicate that you pick that you can pick that initial order that the trial judge determined to either reduce or to reduce in part, to grant or to grant in part the relief. So I hear your point, counsel. I
Okay,
understand the argument that you're making. How's
we
that?
would ask that if there are no further questions, we would ask that the trial court's order be affirmed.
All right, thank you, counsel. Mr. Maneri, you have a few minutes on rebuttal.
I will try to be brief, but I think there's a lot to unpack from the government's argument there.
Can you start with that last piece?
Yeah, I think Your
of
Honor
the
is,
language in D that 3 years after the date the order on the initial application becomes final.
right. I think the government is making sort of a mountain out of a molehill here. There's no grammatical inconsistency by saying that if the court denies or grants only in part the defendant's first application, then you get 3 years from the date of the order. Clearly, the order denying or granting only in part, that's obviously referring to the first time the court rules on that initial motion. Yes, it is possible that there are other orders, but it's still only one order that is becoming final, and it's the first one.
But why? I mean, it's the order on the initial application. If we vacate that order and remand for reconsideration,
Mhm.
that order is gone. How do we or the defendant know whether the clock starts ticking? Forget when the appeal becomes final now. Do we or the defendant know whether the clock starts ticking from the time that initial order, which has now been vacated, was entered, or whether it's the order on remand?
But that order still became final at the time that the trial court was done with the case, no matter what happens on appeal. If it's affirmed, if it's vacated,
That's not how we normally think of trial court orders that have been vacated. I mean, we think of the operative order as the order that is in place after reconsideration and remand, right?
I think for a lot of different purposes, that is how we think of orders that are subject to modification on appeal. An order takes preclusive effect, even though it may still be undone on appeal. An order vests this court with appellate jurisdiction, even though it may be vacated based on what the Court of Appeals does. And just so here, an order becomes final for those purposes and this one, the waiting period, when the trial court is done with the case. I don't think there's any ambiguity about that, even though there might be other additional orders. The text is clear. I want to address, the government sort of keeps harping on this point that the point of subsection D is to provide a roadmap for defendants, to allow defendants and trial courts to have a conversation. It's sort of a paternalistic provision. All of that is made up out of whole cloth. The government might have a sort of paternalistic view of our clients. There's no indication that the DC Council did. Every indication is that what the DC Council was trying to do with subsection D was not to allow for a conversation, not to allow or not to prevent defendants from filing motions because they can't help themselves, but to provide regular, predictable 3-year intervals to measure whether someone's incarceration is still necessary. That's the whole point of the statute. There's no reason to read subsection D to be injecting an entirely different purpose where there is no evidence that the DC Council cared about that. To the point about an order coming at the hearing and an order and the written opinion and which of those is the final order, I think Judge Easterly is entirely correct that the order at the hearing is an order, that the phrase becomes final does serve to clarify when there are multiple orders, which is the order that controls for purposes of the waiting period. I'd just like to note that surplusage is the lens through which we should be viewing that. All we're trying to do is determine whether the phrase becomes final has a role in the statute. Surplusage and the canon against surplusage is just one tool among many to deciphering legislative intent. As I've said, I don't think there is any surplusage under the most natural meaning of the statute. But even if you were not persuaded by that point, that is not fatal to Mr. Williams' interpretation, because you would just look at other indicators of legislative intent. And on that point, we have a really, really clear one in the legislative history that the government has no counter to, which is that in the 2016 committee report, the committee said a second motion can be filed 5 years after the order on the first. Now they've changed 5 years to 3 years. I think that's an indication that the council understood that 3 years is a meaningful period of time.
So can I ask a quick question on the point of the oral decision versus the written decision? You're not disputing that the IRA requires the order to be written. And so are you suggesting that the 3 years could run from the oral decision from the bench, or that it must wait for the written decision? Because I took Judge Easterly's point to mean that the oral decision from the bench could be the point at which the action is taken by the judge to reduce the sentence, but that the 3 years still is dependent on the written order.
Yes, I agree with that. Lastly, let me just say a quick word about COLIE. I think COLIE, for the reasons that we described in our briefs, is completely in opposite. Collateral review is a dramatically different context from second look legislation like the IRA. On its face, COLIE is referring exclusively to collateral review. The meaning of finality in that context and when a conviction becomes final is a judge-made doctrine that is meant to benefit defendants by treating like defendants alike, so that if someone's appeal is still pending and they have not yet fully exhausted their direct review, they get the benefit of any new rulings. It is a meaning that judges created in order to benefit defendants. To apply that from a completely different context, in this context where it would harm rather than benefit defendants, would misread COLIE, would be counter to the purpose of the IRA. And there's no reason that the court should do that or that the council intended for that.
Did you want to say anything about the Corbase, Corbasi, I don't know if I'm pronouncing that correctly, decision that the government referenced?
I have to admit that I'm not familiar with that decision, but Bell, which the government also talked about and relied on in its briefs, explicitly says there's a well-established procedure for a trial court to reduce a motion when this court has jurisdiction over the appeal. In a traditional criminal case, that's an indicative motion that's codified in the rules of criminal procedure.
Do we even have to get there? I mean, Bell is talking about where you have an appeal of a judgment,
Right.
and then the trial judge who issued that judgment is trying to modify the sentence.
I think,
Right. So that's one judgment, right?
Right.
Here we've got IRA, and as we already discussed, you have one case based on one set of record facts up to time A saying you don't get IRA relief now. Then you have another case based on a different set of operative facts up to time B saying you don't get IRA relief now. They're two different cases. They're different judgments. I don't understand why we can't be looking at the time A appeal while the Superior Court is looking at the time B motion.
I think that's absolutely correct. There are any number of ways that a trial court could consider a second motion. One is the way that you just described. To the extent there's any ambiguity about that in general or in a particular case, then there's just an indicative motion. But I think the first answer, the one that I should have led with, is the one that Your Honor just described.
All right, if there are no further questions. I'd like to thank both counsel for your briefs and arguments, and the case is submitted, and that is our final case for today. Thank you. All right.
This court is now adjourned